There's no intro today. There's no intro. I have been talking to you and telling you stories since before Amber called me. The only good thing about this is during my story, I was talking about something that my phone AI had done, and it doxed me. It played my address live over the air, but I was not live. It didn't happen. I told you everything about yesterday. I told you all about the movie. I told you all about meeting just amazing friends and hanging out and the funny thing that happened afterwards and about what I had DoorDashed this morning. Do you guys remember this conversation? Because I just had this with you. No? Okay, in that case, since you guys have all forgotten, here's what I'm going to do. Just this once for you. We're going to re-roll the intro. Here we go. I can't believe I did that again.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
It has been one of those mornings. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Mrs. R.A. can vouch. I did the entire intro. Did you not? Can you convince?
It was really good. I was really impressed. And then he suddenly was like, am I live? I thought, no way. My tech-savvy husband, I'm sure he's live.
I was not live. R.A. found out he was not live. I found out. That was terrible. That was terrible. Welcome to the Court of Public Opinion. Happy Friday. I realize some of you are on your lunch break, and I still have dark circles on my eyes because I just woke up. I literally took a call from Amber and talked to her. I told you before I answered the call, because I was live with you. You guys don't remember this. I told you before I answered the call, I bet she's calling about Sarah Boone. And to answer the call, she's like, hey, boss, not sure if you want to break this, but Sarah Boone's got a new letter. I'm like, I know, I already read it. I've got it pulled up. We're going to do that today. Thanks, Amber. Appreciate the call. All knowing I thought I was live, and I was not. I am sorry. But let me back up. How did you find out? Was it my call? No, I was watching chat finally, because I was looking at Sarah Boone's letter and everything else. I finally switched over to chat, and everyone's like, Rob's on EDB, or, it's Rob time and EDB time added together or something like that. I'm like, I wasn't that late. And people are like, well, maybe something happened. Maybe the internet's out or something. I'm like, wait. And, here I'm in trouble again. Hey, is this DoorDash?
Yes, it is. This is Teresa with DoorDash. Hi.
Hey, can you not say my address on the phone? Is that all right? Okay, sorry. Go ahead. You're good, though. Go ahead.
Oh no, it's okay. So there are two bags of hulls that you requested. One is a 25 count, one is a 30 count. They do not have those in stock. They have the value packs,
the big one,
which are the 80 counts. Yes.
Sure, let's do that. How do I upgrade that?
You know what? I can upgrade it. I think I can upgrade it from my phone. Okay. So let me see if I can do that. If I don't, I will message you and say that you might have to do it from your end. But I think I can substitute that. That would be excellent.
Let me. If not, then just get what they have, and we'll go with that. So appreciate it.
Okay, great.
Thank you so much.
I just wanted to make sure I had your approval. No problem.
No problem. Thanks. Bye.
All right. Okay. Bye-bye.
So as I mentioned, we DoorDashed some cough drops. I told you about this before, that I was DoorDashing basically every cough drop variety that CVS Pharmacy has. Because 80 count Mountain Dew. Ooh, sign me up. Where do I sign up for that? Sorry, brought some pickles in for me. Thank you. Okay, I have to back up. I have to tell you the stories that I've already told you once, which you guys apparently weren't listening for because I was not going live. Last night, I went to a great movie premiere. Here's the shirt for a movie called Thin Walls. Thin Walls that my buddies from North Carolina made. It was a lot of fun. It was definitely what I'd call an independent movie. No big backers. It was just like their savings paid for their movie. It was a lot of fun. It had some parts that were like, oh, okay, where are we going here type thing, but it cut away eventually, and it was neat to see them put together something like that. What was more fun for me was hanging out with John, Justin, and Heidi. John Davenport from chat. Justin is AZ Sun 004, and his wife Heidi were there. John, good friend, spent some time with him over in England. Justin just met, but he's been with us on the channel for quite a while. He also helped me out by keeping me awake on the drive back from Florida with phone calls and talking, which is awesome. He brought the pickles. His wife is amazing. They're just great people. And I honestly enjoyed last night talking with John, Justin, and Heidi more than the movie. And that's not a slight to my friends in North Carolina that made the movie. It's just I'm not a big movie person, but I do like people. And I just had so much fun yesterday talking. We talked, I don't know, an hour, maybe more after the movie let out. It might have been an hour and a half outside the theater there in the parking lot. Just had a great talk. Talked about everything. Families, metal detecting, the trials we've watched, upcoming stuff. Was I dressed appropriately? No. I was in shorts and a t-shirt. And there were people there like in tuxes and formal dresses, formal gowns, fancy glitter. The photographers were there with the lights and the backdrops, and no red carpet, but just about. Okay. And I didn't realize that I had purchased a ticket because it was available. And when I clicked the seat, I'm like, oh, that seat looks good. I sat right like smack dab in the cast and crew section, which is where all the people were in formal wear. Like everyone is dressed nicely. Like at the end of the movie when they all stood up to go up and talk and stand and receive accolades and bow. It's like everyone around us except for John and I, because John sat next to me, stood up and went down there. Like we're in like I was so not in the right place. Oh my goodness. Who is this?
Call from. To accept, press 1. To send a voicemail, press 2.
Hello?
Do you believe in ghosts now?
Is this Donnie?
No. Yes, because I watched the Thomas with the tornado, and you with the parking lot and everything. I was like, do you believe in it more or not? Did you ask around at least about the Skinwalker Ranch in Utah?
No, Donnie, honestly, it doesn't quite raise my interest level high enough to even put it on the bucket list. This movie was about as far as I'm going to go on that one. I just there's enough tinfoil hat talk out there.
I've already seen it. I've seen what you've seen. Okay. It was pretty good. I liked it.
Awesome.
All right, man. I just want to let you go. That was my kid laughing in the beginning.
Sounds good. Thank you, Donnie.
All right, man. Take care.
Bye. All right. Anyway, great talk. Hanging out with those three last night. When it was all over, I'm like, hey, it's late. I got to head home. I've got an early morning. That's what I told them. I said I've got an early morning. Right. My apologies to y'all and to them because apparently I lied to them and to you. So I hopped in my car and I'm like, hey, Siri, give me directions to home, as I normally do. And
getting directions to home.
So Siri says, yeah, I'm getting directions to home. And I hop in the car, start driving. And I'm like, man, I should have just gone on I-215, the ring road, that the bypass. That would have been closer, but it's heading me to I-15 instead. I'm like, this is taking forever. And I got up to I-15 because I'm going through like downtown Salt Lake area. Got up to I-15 and the on-ramp going north was closed. I'm like, oh, and now it's like routed me down through Salt Lake and I'm dragging State Street, 35 miles an hour at the main road right through Salt Lake. I'm like, this is going forever. Just light after light after light after light. And finally it's like turn right and head up towards like Immigration Canyon or something. Wait, right? I need to go left. I look down at the arrival time. says 1 day, 8 hours of travel time, and that'll be home. So I was headed back to North Carolina. So I'm like, reroute back up to Utah. So that delayed me a little further. So I was home late. We do have some kids that are still sick that were up lots during the night. Mrs. R.I. is not feeling the best. Her throat's everything. That's why we have the cough drops coming from DoorDash. And here we are. So let's see. Did I miss everything? Did I tell you everything twice now this morning? The only thing I didn't do was have Siri out my home address, which I did on the previous live stream, which apparently wasn't live. So I guess that was for the better. WeatherWatch says, emphasis on the ish when we say we're going live at 7-ish. Yes. WeatherWatch and Officer Brian, thank you very much for running the podcast. It's weird to be on the rewatch crew on my channel, but twice now. I've got 2 things to catch up on. One on the podcast and one at the end of whatever happened yesterday, which I think the judge didn't actually make a decision. But it's all good. It's all good. We're here now. We do have a letter I do want to bring you, which, oh, wait. I have to do birthdays. Birthdays. Fix your focus. I'm blurry. Okay. If I'm blurry, let me put myself here. Oh, wow. That's terrible. Why didn't you tell me earlier? That blurry was how I feel, actually. That's what the camera was trying to convey to you after a late night, how I feel. I've got all my garbage behind me. Look at this. That's terrible. I've got my press pass for the court. Does that look better if I put the shirt over it? They've got the live view and plugs and adapters and everything. Okay. All right. Yeah, it does look better if you throw something over the top of it, right? Sometimes a neat pile looks better than a messy pile. That's what I say. Yes, congratulations to all of y'all. You hit 60K. I say you because it literally is counting you. This isn't something I did. Thank you, all of you, for making that possible. Yesterday was a lot of fun. We had a little party. Yay! And played the verdict music and celebrated. And you guys were just absolutely amazing with kindness and generous words. Oh wait, internet. I did this as well. I kid you not. Jamie, we had this talk. I told you all about what was entailed. I told you that the ignorance was not innocence when it comes to the law, the violation of be the first in chat rule. We had this talk this morning already. You missed it because I forgot to put the live button on. But we already sang happy birthday while waiting for you, says Gailey May. Oh my goodness. It's been a morning. Happy Friday. I'm so glad it's the weekend, which is just awesome. Thank you. Jamie, internet is all yours. We're sentencing you to internet ownership, which means for the rest of the day, and at least until we go live again, you're responsible for fixing everyone's internet problems worldwide. It seems like a big deal, and it is, but I think you can do it. And this is all because you happen to break the rules about talking in chat. It only applies to the first person. But that was you today. Congratulations, or our condolences, based on how the day goes for you. If you would like a commemorative plaque-worthy certificate commemorating this event, you can go over to the shopping page on the YouTube channel and download your own for the low fee of 50 cents. It's a tiny little fine. All proceeds go to YouTube, and then you can have your own copy suitable for framing or for use as a cover sheet on your CV. Congratulations, Jamie. Thank you very much. Let's see, what f-stop are you on? I'm on 2.0, free sample user, which is probably the problem. I could probably move it up to like a 3.2 and be a little more in focus, because right now that's pretty narrow depth of field. But thanks for bringing in the nerdy stuff this morning, Adam. I appreciate that. Love the f-stop talk. All right. Chat is not on the screen. One more thing I'm doing wrong today. There we go. It's back up. Just needed a day off from chat yesterday. Let's see. Mike W., I'm sorry. Hopefully you got... Hey, did our stuff arrive? Cough drops on the front step. Are you wearing a pirate shirt? I am. Go ECU Pirates. I guess I could turn around and show you, but the chair's in the way. I think it says... Ouch. Okay, headphone cord's too short. I cannot do that. I twisted myself in a knot and then pulled. That hurt. Can't show you. The back says Pirates. Just trust me on that one. All right. Do you need today off? No. We can't take today off. We have Sarah Boone. Sarah Boone has a new lawyer. Lawyer number 10. Lawyer number 10 is signed up. I don't know what this guy's. First of all, here's what I do know. First of all, let's turn chat off for just a second. I can't see chat. Okay, wait. Keep chat on. We have to do birthdays, and then I used to have a tattoo of F-stops. Really? Let's do birthdays, and then we're going to jump over to the Sarah Boone new lawyer motion. It's easy to read because it's typed out. Okay. Let's see. Stop, slow down, be a minute. Hey, can you go get me the Mountain Dew out of the fridge? Yeah, just kidding. We saw the Pirates. The trial's never going to happen. Regarding Sarah Boone. Aunt Candy says Recovery Addict is a mess. Yep, you're not wrong. I don't know if this one's a volunteer. No, well, here's what I do know. Okay, this is sort of funny. We said Sarah Boone does not have money for a lawyer, and Sarah Boone has been declared indigent for the court purposes. You know what that means? Sarah Boone doesn't have to pay for a lawyer. She just has to convince one to sign up to be on her case. This guy looked at the situation and said, hey, if I say yes, he brought me this. I'm thirsty, not dirty. There we go. Okay. All right, we're good. Thank you, little bud. Sarah Boone doesn't have to pay for the lawyer. She just has to convince somebody to work for $15,000, which is the fee the lawyer would get. As every other lawyer has lined up that was worked for her, has lined up and said, I want my $15,000. Sarah Boone is a cash cow for local lawyers. That's what I think. Anyway, so we'll talk about that here in just a minute. Are there any birthdays? Did I miss the birthday wishes? As far as I'm aware, there aren't any birthdays today. Okay, guys, dig deep. Does anyone have a pet whose birthday is today? Heidi's was yesterday? Happy birthday to Heidi. Heidi's a friend of Mrs. R.A. and Diet Coke Mama's. Let's see. The lawyer saw Sarah Boone 4 times already. Yes, this is in the document. If we have no birthdays, I will reserve the birthday song until a point. Miss Trial, your husband's tomorrow. That counts. Because it's the weekend, Kenneth is having a day today. Does that mean, is that a birthday day or just a day? Happy day to Kenneth or happy birthday? Miss Trial, I need your husband's name or nickname, and we can sing to him. Grandma's birthday is today. Okay, so if y'all would be so kind as to put the names in chat, and I need one person to keep track of all the names that are having birthdays today or this weekend, and we will sing to them. And I need them all in one text so I can put them on the screen at the same time and read them. Mr. L, what a good name. Husband's name is Scott. Okay, so let's add Scott. So Scott is on the list. Grace Sanchez, happy birthday. Okay, so who's keeping track? Scott, Grace, Scott, Grace, Emily. Are you guys who's doing this? Scott, Grace, Emily, Caroline. Amelia and Mary. Scott, Grace, Caroline, Amelia, and Mary. Zach. Scott, Kenneth, Grandma, Grace, Caroline, Amelia, Mary, and Zach. Who's helping me out here? This is getting a lot. My son-in-law birthday today, Kenneth. Okay, Kenneth is on the list. Okay, who's got the list? Can somebody post what we have so far? Oh my goodness. Happy anniversary, Mike. That is awesome. On Sunday. Add Zach. Okay, here we go. There we go. Amber says, Kenneth, Scott, Grace, Emily, Amelia, Mary, Zach, Kendall, and Roberta. Is that everybody? Are you guys just giving me like names of people you know? Or are they actual birthdays? Grandma is Mary. Okay, Mary's on the list. So we've got Roberta. Okay, so I just need all these and Finn. So I'm going to do copy. I'm going to paste it myself. Finn. There we go. All right, this is I am stressed out as well. Andrew needs to be added. Hang on. I'll add Andrew. For having no birthdays today, this is a lot of people on the list. Okay, there we go. All right, Finn is on there. All right, here we go. All right, we're singing this. I can't add any more names. This is already like a three-verser. Warm up with me, if you will. La 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 la. Yeah, I've got to keep. I can't see the track change, so this is all we've got today, I think. Happy birthday to you. Happy birthday to you. Happy birthday. Kenneth, Scott, Carolyn, Grace, Emily, Amelia, Mary, Zach, and Kendall. Happy birthday to you. I was trying to fit them all in. All but four. All but four is pretty good. I got 2 thumbs up on the attempt from my youngest son. Let's try again. I'm going to add just a few more here. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Roberta, Finn, Kelsey, and Geraldine, and August, and Andrew. Happy birthday to you. I think we just got happy birthday to you. That was terrible. Happy birthday to you. Happy birthday, dear Michelle. Happy birthday to you. I think I got everybody. That was terrible, though. My apologies. Need more Mountain Dew. That was like a stop type situation. I think we got Andrew. Happy birthday to you. Last one, Andrew. Happy birthday to you. Happy birthday, dear Andrew. Happy birthday to you. There we go. All right. We have sung to everybody and their dogs. I think quite literally. I think literally we sang to everyone and their dogs today. But to everyone who's celebrating birthday today or this weekend, thank you very much. There are a million places you could be, a million people you could be with, but for some reason you chose here. I might say you chose poorly today, but the privilege and pleasure is all ours. Thank you very much for that. Hopefully get your free pancakes at Denny's. Dancers, thank you very much. You know what? I know what the problem is. What is that? Is that a plum? I don't want a plum. I see the problem. Big finish with drums. Thank you very much. I see the problem. I'm on normal latency. Normal latency means I am, I talk and you hear it 15 to 20 seconds later, and then you type something and get a response. And I'm like, I'm not getting the, can I stop and restart the live? I'm not sure if I can. Let me see if I can stop, switch to ultra low latency, and then start again. It should be the same stream. It should just pause. It should like spinny wheel for just a second. If not, so apparently I can't just change the latency. I have to make a new live stream altogether. But for you guys, it's just spinning. So here's what we're going to do. Let's jump straight to Sarah Boone. I'm going to turn off chat here. Man, is it a Friday or what? Let's go over here and bring you Sarah Boone. Sarah Boone has her 10th lawyer. Wow. Sarah Boone, I thought this would not happen. Honestly, I thought this would not happen. But let's see. Let's go view. Let's zoom in a tiny bit. And ready, camera 3. Oh, good thing the lid was on that. And I should probably be in that picture. DV input camera 1. There we go. All right, I pushed all the buttons. I'm on the screen. Look at this. Look at this filing for Sarah Boone. All typed out in Times New Roman font. It is beautiful. It's absolutely beautiful. Proper spacing, everything. I mean, centered, bold, underlines, bullet points. This is a proper motion. I mean, Sarah's done well up to this point, but this is just a proper motion. Comes now to the defendant by and through undersigned attorney under Rule 3.190F of the Florida Rules of Criminal Procedure and requests this court to grant a continuance, that's a delay, of the 3-week jury trial set to begin October 7th, 2024. There's no way this is going 3 weeks. A 3-week jury trial? Not going to happen. The defendant is set for trial by jury on October 7th, 2024. The defendant has just retained defense counsel and a notice of appearance was filed on Friday, August 30th, 2024. 38 days remain before trial. Defense counsel has met with defendant 4 times at the Orange County Jail. This is in person. August 20th, August 21st, August 26th, and August 27th. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession. Oh, thank you. Actually, give those all to Mom. Thank you, DoorDash, for literally all the cough drops in the store. The defendant has disclosed potentially exculpatory evidence on her phone in the possession of Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense. Under Rule 3.2101, of the Florida Rules of Criminal Procedure. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time not only for administering and appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from the interviews with the defendant and supplemented with historical and documentary information from third parties. This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. This notice must be filed by September 7th, 8 days away. The defendant has been deemed indigent for costs. The defense will need government funds to assist in paying the experts in this field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024. The defense counsel responded to her advertisement. What? The defense counsel responded to her advertisement. Sarah Boone seeks lawyer and was retained. The advertisement worked. Did he see it in the copy room? That's what I want to know. Was it the judge's copy room that where he was like, hey, there's a chance? The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this date. The defense certifies this motion is made in good faith. Memorandum of law. The Sixth Amendment to the U.S. Constitution guarantees that any person brought to criminal prosecution in the federal court must be afforded the right to the assistance of counsel for his defense. That's the U.S. Constitution, Amendment 6. See also Ferretta versus California. As the Supreme Court recognized in Ungar versus Serafite, a district court's denial of a motion for continuance may vitate. V-I-T-I-A-T. Hey Siri. Define vitate.
Imitate means.
Nope. Hey Siri.
Imitate means. Good morning.
Can you? Hey Siri. Define V-I-T-I-A-T-E.
Vitiate is a formal term. It means spoil or impair the quality or efficiency of.
Vitiate. I should have known. There's clearly a SH or a CH in there somewhere. A denial of a motion for continuance may vitiate the effect of this fundamental right. Spoils it. See also United States versus Verderame. In Ungar, the Supreme Court stated, the matter of continuance is traditionally within the sound discretion of the trial judge, and it is not every denial of a request for more time that violates due process, even if the party fails to offer evidence or is compelled to defend without counsel. Contrariwise, that is a cool word. I've never seen that word before in my life. Contrariwise, a myopic insistence upon expeditiousness in the justifiable request for a delay can render the right to defend with counsel an empty formality. Oh my goodness. Who wrote this? Who wrote this opinion? It's beautiful. Contrariwise, a myopic insistence upon expeditiousness in the justifiable request for delay can render the right to defend with counsel an empty formality. That's almost like the Thomas Jefferson letters. It's like, wow, that's beautiful. Beautiful language, flowery, and I have to define all the words, but it worked. The right to assistance to counsel not only reaches this trial stage, but it extends to sentencing as well. See Jones v. United States. Further, the Supreme Court has stated that implicit in this right to counsel is the notion of adequate time for counsel to prepare the defense. The prompt disposition of criminal cases is to be commended and encouraged, but in reaching that result as a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. Powell v. Alabama. Wherefore, the defense would respectfully request the court to consider this request to grant the defense motion to continue. I now certify that I filed this properly. Attorney James Owen, counsel for Sarah Boone. James Owens was down at the courthouse and he was thinking, man, I've got my law degree. I'm here at the court. Where are all the customers? Where are they? Where are my clients? Why aren't people beating down my door to schedule my services in their defense? And exasperated, he went to the judge's break room because that's where the good stuff is. And he probably paid for an overpriced ramen and used the coffee maker to pour some hot water in. And then, of course, he went to the beverage machine, and he was about to take a Mountain Dew, but realized he didn't have enough quarters for Mountain Dew. So he went over to the water fountain. And he bent down, and he let the water spray on his face a little bit, just as without drinking, just like brush against the lips, wet his lips. It's parched from praying for clients. And then as he took a sip and let the cool water soothe his throat, and he sat up from the water fountain, and there ahead of him on the wall, big poster, laminated poster, and the words Sarah Boone seeks attorney. They almost glowed, and he realized this was a sign, if not from heaven, from the judge, that he had a calling here in Florida, that he had not gone through law school for nothing, that there was a defendant out there who desperately needed his services, and that it was not just chance that he was there sneaking food from the judge's break room. Mr. Owens, good on you, my friend. Good on you. Good move. Thank you. That concludes my TED Talk. Let's see. Let's see where Chad is. I'm sorry. I promise I have not had any Mountain Dew today. I promise. Okay. The bottle is sealed. I did drink another one just like this last night, but I think the effect should have worn off. He gets $15,000 for this, which is not a lot considering this is a murder trial. Okay, $15,000 is a cut rate fee for a murder defense. But good on him, James. All right, let's check him out. Google him. Let's check him out. I don't know anything about him. I don't know if he's a seasoned attorney or if he's wet behind the ears. I will say this, and Mrs. Ari was right. His arguments were sound. He argued all the right issues with the right case law, and even acknowledged in the last sort of thing. He acknowledged the weaknesses in his argument. It's like, look, I understand. This is usually within the trial court's discretion when it comes to continuance, but here this is the balance we're trying to explain. She's got some rights. I'm brand new here. I'm willing to do this, Judge. We can move this forward, but I need just a little bit more time. Not sure if the judge is going to grant that. We'll have to watch the schedule to see when they have a hearing. The judge will have a hearing right away to address this. And Sarah Boone most likely will not be speaking at that hearing, although she will be present. Googling him right now. He's been a lawyer since 1986. Trial lawyer since 86. A seasoned attorney. 35 years as a lawyer per his website. Private practice, criminal defense, 20 plus years. He's probably got a caseload.
Do you think that he took it like he felt like she needs a lawyer?
Maybe he just looked at this and said, you know what? It cannot be justice to have this woman accused of murder defend herself against her own wishes. Maybe it was just an ethical thing for him. Or maybe it was the artwork on the Help Wanted poster. Let's see. James Owens Law. I'm looking at his website. Thank you, Amber, for the link to the website. Oh, he's stylish. He's styling. I see his picture there with and he says text. He gives out his phone number first. He's like, "Hey, here's my burner phone." James Owens, attorney at law. Build a solid defense. Meet with James Owens, attorney at law, to discuss your case. If you're facing criminal charges, every second counts. Never has that been more true than in Sarah Boone's case. While the prosecution is gathering evidence against you, you'll need an experienced lawyer who can defend your rights. Don't delay. Contact James Owens right away. Put your poster in the judge's break room. Right away to hire a skilled criminal defense lawyer. He'll stand by your side and fight tirelessly for the best possible outcome in court. As a top lawyer, top Florida trial lawyer since 1986, James Owens has handled countless cases. I believe that is a mistake. That is a false statement on James Owens' part if he made that. I believe it's possible to count how many cases he has had. It might be a big number. It might be a huge number. It might be very impressive, but I believe with the way courts work, where they keep track of every trial that he has worked on, that it's not countless. Countless would mean that it would be impossible to count. So I think he's maybe embellished, maybe a little bit too flowery on this one. Countless cases from simple misdemeanors to serious felonies. He'll help you. Oh, it was somebody else. He'll help you. It wasn't his statement. He'll help you understand your rights and explore every legal option. Text James today to schedule an appointment. Why should you choose James Owens, attorney at law? A guilty conviction for criminal charges can potentially ruin your future. You need to know your criminal defense lawyer is looking out for your best interest at all times, and that he believes you, and that he listens. Oh, he doesn't say those things. James Owens provides tremendous value to his clients with over 35 years of experience in the courtroom, knowledge of both sides of the law as a former criminal prosecutor. He's switched teams. He knows the playbook. Convenient virtual consultations. She doesn't want those. And text availability. That's not going to work either. Personalized legal strategies with proven results. Attorney Owens has taken over 100. Now they count him. Now has taken over 100 jury trials to a verdict. To a verdict. He may have lost every 100, but so He tried. Good on you, James. You did a good job. 100 jury trials to a verdict. He'll be your strongest advocate in court and offer unrelenting representation on your behalf. There is no case too complex. There's no suitcase too complex. James Owens has decades of experience representing clients facing a wide variety of criminal charges. Turn to him for assistance if you've been charged with, here's the list. You guys, when you hear the right one, go ding, ding, ding in your head. DUI, murder. Yes, I heard it. That was armed robbery, aggravated assault, theft or robbery, sexual assault, or domestic assault. From bail hearings and plea bargains all the way up to trial, Attorney Owens will be with you every step of the way. He'll challenge the evidence presented by the prosecution to give you the best chance at a reduced sentence or drops charges. Wow, James Owens. You know, you can't fault the guy. You can't fault the guy for responding to a very, very well-designed ad, if I say so myself. It was a beautiful ad. Sarah Boone seeks attorney. I have a shirt. I have a shirt with it. Maybe he saw my shirt. Greeners, I think it was the shirt that did it. I'd like to say we had a little part in a very little part in making sure Sarah Boone was represented for her trial. He might have seen our live stream coverage. Maybe I should send him. I don't want Greeners. Don't make another shirt. Maybe I'll send him the one you sent me. How about that? Because I don't think I'm going to wear it anywhere else. I could sign it, send it to him. He's guaranteeing Sarah a verdict. That is an ironclad guarantee James offers. I mean, how many attorneys can guarantee their clients that there will be a verdict in their jury trial? That's him saying, not hung jury. I guarantee either we win this thing or I'm going to blow this completely out of the water and you're going to be guilty, guilty, guilty. Those are your two options, Sarah. I don't know which one he's leaning towards, but 4 times he's met with her. That is impressive. That's almost, that's twice a week is what I saw based on the calendar. That's pretty good. I mean, I think Sarah Boone probably needs a little bit more, but I think that's pretty good for what they're doing. Everyone gets a verdict is not much of a promise, says Pretty Iced Tea. Yeah. But, in the alternative, there are lawyers out there, and this is, I think, what he was actually speaking to when he says that. There are lawyers out there who are settlement lawyers. It's like, it's my job to get you a plea deal, and then I'm out. I just don't like trial. My goal is to get a plea offer, and you take it. And then I get paid. There's no trial. There's no court. There's no, all that hassle. There are lawyers out there. James is saying, I'm not that guy. Well, I'm not that guy, but
because he's the guy.
He's that guy. He's the guy that will go the distance in the case, all the way to the verdict. So, congratulations, Sarah. I have to say, it worked. Sarah was right. I will say this now. I'll put it on the record. It worked. She knew she needed an attorney. She knew what she had to do to get one, and it just involved a couple pens from the commissary and a full page of paper, and of course the judge's break room. But beautiful, beautiful. All right. Let's see. Where do we go from here? Judge Cedric has been spicy this morning, I hear. And I'd love to thank you, Kate. Appreciate that. I'd love to go pop into his court. We also have Judge Wolf, who's out and about in the Heavenly Wood courtroom, doing his thing with the Chancery docket. Are we watching anything? We just barely finished the sentencing for Robert Tellis. We watched that with Brandy Churchwell. We had Brian Kohberger's hearing yesterday, which I feel like I lost some brain cells during. Not because the arguments were bad, but because the PowerPoint presentation was terrible. All 4 of them. What points? on BK. Oh, highlighting BK. Yeah, let's summarize because I didn't get to do that on BK really quickly, and it will be quick. It will be much quicker than any of their PowerPoints. This is what defense says. We need to change the venue for Brian Kohberger because in Latah County, it would be impossible to seat a jury, or very, very difficult to seat a jury that has not been biased by the press coverage that has occurred in this case. They did a lot of studies to see exactly how many articles, how many mentions, how many tweets, how many Facebook posts were made in Latah County, and did some higher level math estimation to figure out how many people potentially saw that. And to back that up, they also did surveys where they called, I don't know, what was it, 1,800 people, 1,400 people? I forget. It was a lot. Basically, of the few people that didn't know about the Brian Kohberger case, they called and told them about the case. And so they pretty much solidified the fact that it's impossible to find a jury in Latah County that would be fair and unbiased, that doesn't have this prejudice. And they went so far as to have 3 witnesses tell the judge, just for your information, Your Honor, when you tell the jury to disregard something, that doesn't work. And there's evidence, scientific evidence to show that doesn't work. I don't know how the judge wasn't a little bit offended about that, because that is like a staple of the courtroom, to strike something from the record and say you should not consider that in your deliberations. I've struck that from the record, pretend as if that didn't happen. We've seen that in almost every single trial, but these 3 experts that were certified as experts in court to testify on this said that doesn't work. So they're saying you can't just have somebody come in and say, yeah, well, I have seen it, but I'm not going to be biased. I'll just set that aside. They said, can't do it. You cannot do that. We have to move this to Ada County. Now, the funny thing is Ada County, first of all, it's much bigger. Okay, it's much, much bigger, a huge jury pool selection. But they would basically have to do the same process because the media coverage is nearly the same in Ada County. There's some slight differences, but initially it was higher coverage in that area when the first news broke about the murder. And there still has been continuing coverage throughout, even though its interest level has dropped below where it is in Latah County.
Yeah, the fear factor is different.
The fear factor is different?
Yeah, like the people in Latah County are...
Yeah, people in Latah County were scared. The students wouldn't go back to school, people wouldn't go to work, things like that. But in the Boise area, they didn't have that same fear. The arguments were pretty sound. I would say the math checks out. There were a couple... I think probably the most impactful slides for me out of this all the presentations was the one that showed other cases in the area that were moved because of prejudice and how many news articles they had, how the numbers compared, basically where Brian Kohberger fell on the scale. And the only thing they didn't show was Daybell on that scale, but they said Daybell got less coverage than Brian Kohberger, and they just showed all the cases that were moved because of the coverage. That was pretty convincing for me. I think it will be moved, but the judge reserved the right to do that. The defense, on the other hand, the prosecution, who was defending against this motion to move the trial, change the venue, said it's going to be the same. The effort's the same, and plus look at the costs. Look how much it's going to cost to move the entire court to Boise, 300 miles away.
Wait a minute. Defense wants to stay?
No, the prosecution defended against defense's motion. Does that make sense? Did I say that wrong? They argued against it because this was a motion from the defense to move the venue. Prosecution was fighting against that. So prosecution had one bite of the apple where the defense got to make 2 arguments for change of venue. I think that's how it worked. They're saying, look, it's going to cost a ton. Look, the hotels, everything, all the court staff that have to be down there for 3 months away from their family, the prosecution, the witnesses that will have to travel. I realize some are actually closer to Boise than here, but most of them will require all this. They said, yes, we understand that Boise can handle big courts, and they have handled big trials before. But we have time for this staff to learn, to prep, to get ready, and we can do it just as good as Boise can. That's their motion. I don't think the prosecution is going to win this round. I don't. I think it's going to be moved to Boise, and as soon as the judge makes his decision, which probably will come in the next maybe week or 2, I don't think it will require much more than that. It is a decision that has to be made quickly because both sides need to start scheduling and getting their their expert witnesses lined up with hotels and things like that. And they need to know where they're flying into and where they're going to be staying and where they can schedule. So that is something that has to be done soon. Anyway, Brian Kohberger, that's going to be a fun trial. Either way. And I've been thinking about this. I would like to be there for Brian Kohberger, but it is a 3-month trial. That is too long for me to be gone from my family. And bringing my family with me for 3 months would require me winning the lottery, and not just one of the small ones. Like we're talking like the Powerball with all the numbers. So Weather Watch, if you can buy just a couple more tickets under our Split It With Me agreement, that would be great. I'm not sure how we're going to do BK. We know that we already have access to the feed from court, and that's the only feed that will be available. But we'll see. Weather Watch is like on it, headed to the gas station right now. Thank you, Weather Watch. It's a long one. I've already looked at Airbnbs in the area. We looked at rental RVs, like actually living in a camper. That's double the cost of an Airbnb. The cheapest Airbnbs in the area that put you close to it would be around $100, and even then I would still need a rental car. It's I don't know. What's that? Mrs. Ray says, you could stay with my friends. That's a long time to impose on somebody for 3 months. That's like 2 weddings, says Free Sample User. What amount is the lottery up to, says Abby. Happy birthday tomorrow, Kathy. I apologize if we didn't sing to you. We sang to everyone else. I apologize. Happy birthday. Hope you have a great birthday weekend. Please consider yourself sung to. I apologize we missed you. All right. Let's see. We've got Donna Adelson motions hearing this morning. We've got Judge Cedric. I'd like to jump to his court. I've heard that it's spicy. We'll jump to that in just a minute. Greener says, I always play the numbers 8675309. I can see that. I see that. I have not followed Donna Adelson at all. Guests start to smell like fish after a week. 3 months is long, says Laura. Yeah. The alternative, and I'm not a big fan of this, is camping. And I'm not talking under an overpass. I'm talking like a legitimate in a campground. And I think most state campgrounds only allow you to stay like 14 days. So I'd have to like have like 2 or 3 campgrounds I circle back to, and just, literally pitch a tent and just you guys heard Mrs. O'Reilly just bust up. I would like to be there for at least part of it. But it's sort of going to be a media circus, and at the same time, it might not be, because what do you benefit from being there, right, for 3 months without a court feed, without cameras in court, and honestly, most people aren't even going to fit in the courtroom. Tent camping or glamping? It would have to be tent camping, because glamping is, once again, about as expensive as an RV. They'll be closed for winter. All right, snow comes early. I've got good gear. I've done winter camping.
I picture you in a tent with all of your electronics.
The problem is, it would be a fire hazard, because I'd have like 7 extension cords going into my tent to charge everything every night, like all the cameras, the computers, the tablets. When is BK trial, Lori? The date, I think we're set for like March. They wanted it. It might be June. They wanted it during the summer when there's not a school, like classes in session for school. That's if it's in Latah County, because the county in Latah it can adjust for an influx of students for a school year, and it does. It constantly does this accordion sort of thing. They have space for all the students. If they have all the students there though, and they bring BK in, it won't last. But Ada County obviously is bigger. Boise has much more options that can absorb that a little bit better, and thus the schedule might also be able to shift. But I don't think they'd want to shift far, because we're already dealing with the judge's schedule and their court schedule, even though we're in a different courtroom location. So I think it would be the same. Denise says check burner. Checking burner. Let's see. Sarah Boone has counsel. RA, are you awake? Did you party too hard? Did you make it home last night? I'm worried about you. Where are you? Which one was it? I've got a lot of messages here. You will benefit meeting me. Denise, yes, you're going to be up there for sure. Denise, also one of our court watchers for the Daybell trial. Oh, wow. Oh, my goodness. I see somebody has laser engraved something that says Recovery Addict 60,000 on it. All right. Let's see. I love that the lawyer responded to her ad. Pretty cool. And he's already seen her in person more than the other ones. Yeah, in 2 weeks, he's done more than some of the other lawyers did in several months. Let's jump up to Judge Cedric Simpson. I think he's got something going on, and I'm not sure what it is.
1200.
Yeah.
You got an appointment with Hawk on the 5th.
Mm-hmm.
And you put in a DHS. How many people are in your house?
4.
Okay. So the most they would come up with on that would be about $740 if you qualified. So okay.
This is landlord-tenant stuff.
All right. So here's what I'm going to now. You paid the landlord. You said $1,000.
Yes. So it was previously 3,000. I did recently pay 1,000, so it brought it down to 2. And then I spoke with the property manager yesterday, and he stated that that 1,000 that I paid will go towards September for me to do the first month agreement that I just signed yesterday.
Okay. And Ms. Ingen, I don't think you know anything about that, right?
I don't.
All right.
I'm useless
So
today.
here's what we're going to do, Miss Ward.
Okay.
I'm going to adjourn your case out to September 6, 2024 at 1 p.m. Okay. Let Ms. Ingen check into that agreement, see if we can get that worked out. It sounds to me like they're trying to work with some of the tenants. So just do that first, and then it might change. We might change what we want you to do, but let's do that and let's see what that is. Okay.
All right. I do have a question for you. I have an appointment. I have a disabled daughter. She has an appointment with cardiology at 1:45 for September 6th. Am I able to come in earlier, or do you know how long it'll possibly be for me to still make that appointment with her?
Okay. So your daughter has to be at, okay, here's the thing. That's at your appointment with the doctors at 1:45?
Yes.
Okay. And can you make a note of that?
Yes.
Okay. Here's the thing. If you're able to Zoom in, I'll let you appear via Zoom, okay?
Okay.
You go ahead and take care of your family. If you're not there, we're going to note the file that you've got that. So nothing's bad's going to happen. Just try to get yourself in when you can, okay?
Okay. Thank you so much.
Would it
Not
make
a
sense
problem.
to put it out another week, Your Honor?
I'm going to jump.
You want to do it that way?
I'm going to
Okay.
jump. I'm going to jump to Judge David Wolf, who's in Chancery, Tennessee.
Well, Your Honor, if I could, it's a motion to dismiss his petition for failure to prosecute. Jason Adam Slayton, are you here? Mr. Slayton filed a petition in this case to legitimate. He was represented by Ms. Lynn Coffinberry at the time. That petition was filed in October of 2021. No action has taken place in that matter. We've served discovery.
It's in Tennessee.
Mrs. Coffinberry came before the court last month and was relieved as counsel. This matter has laid dormant on the court's docket since October of 2021, and we would ask that his petition be dismissed for failure to prosecute.
Jason Adam Slayton in the courtroom. There's no failed to prosecute your case. The case is dismissed. Failure to prosecute.
And Your Honor, we have a further in our pleadings that we counterfiled. What we have is
you should argue that one before I dismiss the case.
Well, but you dismissed his petition.
You have a counter petition?
I believe I did. And it is a name change, Your Honor.
I knew you had a motion.
Answer and counter complaint.
Amber, can you get me the time, like a link with a timestamp it built in?
Answer and counter petition.
Yes, Your Honor.
His petition is dismissed and you're proceeding on your counter petition.
Yes, Your Honor. On that counter petition, what I'm proceeding on is requesting that the youngest parties, they have 2 minor children born together. The oldest child bared Mrs. Harrington's maiden name. Their second child, Ezra Croft, they denoted as the father's name of Slayton. Mr. Slayton is not in the picture anymore. He's had no contact. He's had nothing to do with the children. Mr. Ezra is now in school and would like his name, and my client would also like his name changed so that it's consistent with his older sister and his mother. And we're asking that Ezra's name be changed to Ezra Croft Harrington. And if we could raise your right hand.
Again, without any opposition, your motion is.
Okay.
Well, let's put her on.
If you, I just, it's okay, yeah, go and raise your right
Ms.
hand.
Roberts was to tell me how to do things. So.
You think it's in your child's best name for both of them to have the same surname, which would be your maiden name, is that correct?
Yes.
And you're not changing Ezra's name for any reason to defraud creditors? He's not under criminal prosecution?
Absolutely.
You're not trying to avoid anything, you just simply want the continuity for him? Is that right?
Correct. Mm-hmm.
Thank you, Your Honor.
The motion is granted.
Thank you, Your Honor.
Thank you.
All right. Nothing done, nothing left to do but to pay the attorney.
Ms. Roberts and Ms. Duke. Cantu versus Castro.
That's for a final hearing. If we have to try, it'll take probably 4 hours.
All right. Second call.
This lawyer's busy.
I'm the one who's filed the petition today to probate the will that's on file with the court. I do have 3 witnesses here.
All right. Then this is a contested issue, is that correct?
Contesting a will. These are always juicy in his court.
Again, I don't think we submitted it to probate. Excuse me. I represent the 2 biological children, the surviving heirs of Mr.
This is the case that we had some hearing in the past, and there was an issue raised about the actual witnessing of the will itself, correct?
Yes, Your Honor. Ms. Hassel filed to admit the will to probate. There was testimony taken at the time. One of the attesting witnesses I questioned at the time, and he testified that he was not age 18 at the time, when in fact he was age 18. And then the other attesting witness did not recall whether or not everything was signed in the presence of the testator and the testator signing in their presence. So Your Honor admitted the matter, admitted it for an administration and appointed Ms. Franklin as the administrator, CTA, and then St. Jude's, who is now the beneficiary of the will, other than one individual who's represented by Mr. Stan Reynolds, who has a life estate and a piece of property. She's taken depositions, she's deposed the parties, and now they're back to submit it. And I anticipate if their testimony is consistent with what the testimony in their depositions were, then the matter will be admitted to probate. And then I have filed previously a notice of a will contest. So once it is admitted, then my clients may choose to file the will contest.
So that I'm clear, the issue of whether or not this will should or should not be submitted to probate is not contested. Am I correct? Anyone contesting that issue alone, then I'm going to admit the will to probate. If you want to put on your proof regarding the execution of the will, then we can do that. And then the will can be admitted to probate. Then we can consider the will contest issue. So if you will, you have your witnesses for the execution of the will here.
I do.
All right.
They're present.
If they'll step forward, both of you who are going to testify, or anyone else who's
We have
going to
3.
testify, raise your right hand and let's place you under oath.
There's like 6 people raising their hand out there.
You may put on your proof.
Thank you, Your Honor. I call Hunter Ashley first.
All right, Hunter Ashley, it is you. I'm going to ask you to speak well enough that that microphone will pick you up, okay?
All right. Can you state your
Actually,
name?
we can do it from the witness stand. Let's
Yes,
just
Take a
bring him
seat.
over
Let's
here.
make this official. There we go. Activate witness cam.
Your Honor, I don't think that the rule is being invoked by Ms. Roberts, but out of an abundance of caution, I'd like for the witnesses to be able to step
Anyone
outside.
else who's going to be a witness, just have a seat somewhere until we're ready for you. All right?
3 witnesses outside.
Can you state your name for the court, please?
Hunter Ashley,
How do you spell your last name?
ATCHLEY,
And where do you live?
Charlotte,
Where do you work?
Dixon County Tire and Oil.
Did you know Willard Nelson Cummings?
Yes, ma'am.
What did you call him?
Bill.
Bill. Everyone called
How
him
did you
Bill.
know him?
I worked for him.
How long did you work for him?
It was on and off, total probably a year and a half.
And what did you do when you worked for Mr. Cummings?
Pulled transmission, stuff like that, anything he needed done, really. Just all kinds of stuff.
Did he own a business?
Thank
Yes,
you, Legal
ma'am.
Vices,
What kind
for
of
the
business
raid.
was
A
that?
transmission shop.
And that's where you worked?
Yes, ma'am.
And he left the will to you?
Were you working for him in September of 2021?
Yes, ma'am.
How many days a week did you work for him?
5.
And Mr. Cummings was operating the business on a daily routine schedule in that period of time?
Yes, yes, ma'am.
What makes you laugh about that?
He was there 3 o'clock in the morning to almost 3 o'clock next morning.
He was a hard worker. He was a hard worker.
He was always in that shop.
The will that we're offering has already been made a part of the court file. I have a copy that I'm going to provide the witness.
I have the original as well. So.
It's the one dated September 15th, 2021.
September 15th, 2021.
Now everybody has a copy of the will. You think this guy left his transmission shop to his
Have you
employee?
seen that document before?
Yes, ma'am.
Does that appear, well, let me ask you to turn to page 2 of that document. Do you see your signature on page 2?
Yes, ma'am.
Did you sign that document?
Yes, ma'am.
Hang on.
How did you come to serve as a witness for Mr.
Is he a notary
Willard
public?
Cummings' will?
I just worked for him.
So tell me how it unfolded.
That morning I came in, I was late. I was late as usual. I was in the back. Randall and him was in the office. I heard a truck fire up a few minutes later. Randall ended up walking back here and telling me we was going to the lawyer's office. I had no clue why, I wasn't really asking. We were getting out of work and getting paid for it. And closed up the shop and we went on down there.
You mentioned somebody named Randall. Who's that?
Randall, that's a coworker.
Your coworker. And is his name on the will as well?
Yes, ma'am.
Did he sign?
Yes, ma'am.
So Randall was the one who told you that you needed to get in the car,
Yeah, we
going
were
somewhere,
We were closing up and going down to the lawyer's office.
going to the lawyer's office.
Yes, ma'am.
Did you know what you're going to be doing there?
No, ma'am.
Did you take anything with you?
I think I might have my phone in my pocket, my wallet.
Did he say anything about your ID?
No, ma'am.
No?
They got my ID, but they didn't have any questions about it or anything.
How did you get to the law office?
I rode with Randall.
Where was Mr. Cummings at this time?
He'd already went on down
Went on down where?
to the lawyer's office.
Had you seen him that morning at the shop?
Other than just walking past his door, him and Randall was in the office. I was late. I wasn't really trying to talk to him. I was
sneaking
Weren't trying to catch his attention.
No, I was sneak on by.
I was late as usual.
So Mr. Cummings left
Yes, ma'am.
the shop,
Yes, ma'am.
and you and Mr. Anderson
Yes, ma'am.
followed. Okay. Where were you going? You said the lawyer's office. Do you know
Yes.
which lawyer?
I'm pretty sure his name is Mr. Jackson. I can't remember exactly the whole.
Had you been there before?
I'd never been there before.
And what was Mr. Cummings there when you arrived?
Yes, ma'am.
All right. Tell us what happened when you got to the office.
When I walked in, they were standing right in the office. Not in his office, but
Who's they?
His assistant, the judge, and Bill. They were all standing right there.
When you say the judge, you're referring to the attorney.
Everybody calls it, that's just how.
Understand. So you walk in and you see Judge Jackson, his assistant, and Mr. Cummings?
Yes, ma'am.
And who did you walk in with?
Randall Anderson.
And what happened next?
We walked in and stuff, and we went into his office, and we sat down on to the right. There's two little chairs sitting there. We sat on down. Him and Bill kept cutting up. The assistant ended up taking our license and stuff. They were cracking jokes half the time. I can't remember the jokes they were cracking, but Bill always had jokes.
Yeah,
so they cut up and all that stuff. They took our license, and then we waited for them. They pulled out the wheel and all that stuff. They talked. I can't remember them talking and everything, but like I said, the jokes. They sat there and Bill. I remember Bill bending down to the desk. I can't recall him exactly signing it, but I remember him bending down. And they had me and Randall bend over to the desk from our two chairs, and we signed our names onto them.
And were you and Randall and Mr. Cummings all at the same desk?
Yes, ma'am.
Okay. You said you remember him bending down. What was he doing then?
That's what I'm saying. Yeah, he's got a bit. That's when I think he was signing it, but I can't exactly recall him signing it other than him bending down.
Okay. And then what happened after he bent down?
They continued to talk for a few minutes, and we continued to sit there and just wait, and then they let us go on out.
When did you sign the document?
It had to be after they were sitting there talking and stuff. After Bill.
After who was talking?
Judge and Bill.
Was it after you saw Mr. Cummings bending down?
Yes. Yeah.
And when you said that you signed and then Mr. Anderson, or do you remember the sequence?
Not really. If I'm not mistaken, both of us was leaned up at the desk at the same time. I can't remember if he signed for me or if I signed after him.
And how close was he to you?
Or side by side.
This guy's. I was late as usual. Hey, y'all, get out from underneath that car, wash up your hands, or head down to the lawyer's office, going to sign
Who
me a will.
Who asked you to sign document?
I can't exactly recall who asked.
Okay. Was it ever acknowledged that you were there to sign as a witness for the will?
Once we got in there and they were talking and stuff, and after Bill, that's when we knew what we was doing.
What was your understanding then?
That we were signing Bill's will, his final will.
When the will was passed to you, had the will already been signed by Mr. Cummings?
Yes, ma'am.
Yeah, he has no dog in this fight.
And then after Mr. Cummings signed, you and Randall?
Yes, ma'am.
The both of you signed. Okay. At the time that Mr. Cummings executed the will, did he seem to be in good health?
Yes, ma'am.
Okay. He understood what he was doing?
Yes, ma'am.
He knew who his family was?
Yes, ma'am. He was the same old smart aleck he's always been.
Okay. He had a clear mental state?
Yes, ma'am.
He knew what his assets were?
Yes, ma'am.
We were previously in court, and an issue arose about how old you were on the day that you did this. When were you born?
January 16th, 2003.
(2003)
I have
I did bring my ID if you need it.
I'm going to ask you to pull your ID out. I'm also going to hand you a document.
All right, stipulated that he is of age at the time of the execution of the will, correct? All right.
He's 21,
I assume that does away with the need for a copy of that. The record will reflect that there is a stipulation of the parties that this witness was of age at the time at least 18 years of age at the time he served as a witness to the will.
Judge, those are my questions.
Roberts, do you have questions?
So clearly the guy left his
So just to
inheritance to
summarize,
people other than the family, because the
you
family's
went to
contesting this.
the law office of Andy Jackson, is that correct?
Yes, ma'am.
While you were there in the back office or the office there with Mr. Jackson, Mr. Cummings, and Randall, the other witness, along with Mr. Jackson's assistant, his secretary.
Yes, ma'am.
Were y'all all there, and did everybody sign while you were all there in one room?
Yes, ma'am.
Anything further? Thank you, sir. You may step down. Call your next witness.
Do I take these copies or do I leave?
Can you do what?
Do I take these copies or do
No,
I?
you'll hand them back to her, if you
Okay.
will, or you can hand them to the bailiff if you want to. He'll give them to her.
I love these contested will hearings. These are juicy.
Thank y'all.
This guy,
Okay, maybe Officer Duke, they may be in the courtroom.
he's a hired
Who are you
hand at the transmission
Randall
shop,
Anderson.
dragged down to a law office to sign a final will and testament that appears to cut the gentleman whose will it is, his descendants, out of the will. And now he's here testifying. He's like, yeah, he was sane. I was there. We were signing. I was getting paid. I was late. He was fine. He was happy. I was like, doesn't matter to me what we do. It's either pulling transmissions or signing wills. I get paid the same either way.
To the witness stand, raise your right hand, and let the clerk place you under oath.
Here's his buddy from the transmission shop. I love this.
Can you state your name for the court, please?
Randall Eugene Anderson, Jr.
Where do you-
I'm going to ask you to do me a favor. Take the base of that microphone and pull it toward you.
Yep.
There you go. All right.
Where do you live?
Burns, Tennessee.
And where do you work?
Dixon County Tire and Oil.
Do you work with Mr. Ashley?
Tire and oil. That's tire and
Did you
oil
know
for the rest
Willard
of us.
Nelson Cummings?
Yes.
What did you call him?
Bill.
How did you know Mr. Cummings?
I worked for him
How long?
10 years.
Were you working for him in September of 2021?
I'm sorry, I don't recall.
Okay. What were the things that you did for Mr. Cummings?
Rebuilt transmissions. Whatever really he needed me to do, I would do it for him.
I was just
What
a
was his
hired
business,
hand.
Mr. Cummings?
Fixing transmission.
And that's where you worked?
Yes, ma'am.
How many days a week? What were your hours?
8 to 5, I believe, Monday through Friday.
But I was always late too.
I'm going to pass you a document.
It can be ugly. It can be ugly. Also, it can be funny, as the person who passed
Have you seen this
sometimes gets the
document
last
before?
laugh.
Yes.
I'm going to ask you to turn to page 2. Do you see your name?
Yes, ma'am.
Do you see your signature?
Yes, ma'am.
Did you sign the original of that document?
Yes, ma'am.
It's dated September 15th, 2021. Is that accurate?
Yes.
Okay. And were you working for Mr. Cummings on that day?
Yes.
Okay. I don't believe I made that an exhibit to the hearing. I do want to go ahead and make that an exhibit,
All right,
a
let's
copy
make-
of the will.
We'll make a copy of the exhibit rather than the original.
Sure.
You'll hand that to the clerk, please. Mark it as Exhibit 1.
Greeners. That was a stretch, man. It's shifting business.
How did you come to serve as a witness for Mr. Cummings' will?
He asked me to come down to the lawyer's office,
Where were you when he asked you that?
the transmission shop.
I was under
Did you go
67
by yourself?
Chevy.
No.
Elbow deep in
Who did you
transmission.
go with?
Mr. Ashley.
Did you go with Mr. Cummings?
No.
When did he go?
He wanted us to wait, I forget the time, 10 to 15 minutes after he left, just to meet him down there.
Meaning you and Mr. Ashley to come meet him down there?
Yes, ma'am.
Okay. And you left the shop?
Yes, ma'am.
Who drove?
I did.
It was just you and Mr. Ashley in the car?
Yes, ma'am.
And where did you go?
To Mr. Jackson's office.
Did you know Mr. Jackson?
Yes, at the time, yes.
How did you know him?
He handled Mr. Cummings' rental.
What do you mean by that? Did Mr. Cummings have a kind of another business that he?
Yes. He had a bunch of rental properties.
And Mr.
So there's probably
Jackson
some
was
money
his lawyer
here.
to help him with the rental properties.
Evictions and stuff.
So, and you knew that just working from, or excuse me, you knew that just because of your work with Mr. Cummings.
Yes, ma'am.
All right. So when you got to Mr. Jackson's office, who was there?
Mr. Cummings, Mr. Jackson, and his secretary.
What happened when you got there? Where did you go?
To the back room to his actual office.
Meaning Mr. Jackson's
Yeah,
office?
Mr. Jackson's office. Yes.
And did you sit down somewhere?
Yes, at a table.
Who was at the table?
When we walked in, nobody was at the table.
And when you sat down, who was there?
Me and Hunter.
Where was Mr. Cummings?
He was at the other end of the table. I'm sorry.
All at the same table?
Yes.
And after you sat down, what happened next?
I can't recall.
Okay. Did anyone at any point ever examine your ID?
Yes.
Who was that?
The secretary. They made copies of both of our IDs.
She took it from you?
Yes.
And brought it back?
Yes.
And who, when you sat down at the table, what did you understand was happening?
I don't recall. I knew it was something to do with his will. At the time when we got there, I didn't know what really for. I knew I didn't know what it meant to witness a will.
But you knew you were there in connection with Mr. Cummings' will.
Yes.
Just signed and you didn't know what you were doing?
Did, when you were sitting at the table, were there documents in front of you
Yes, ma'am.
and in front of Mr. Cummings?
Yes, ma'am.
Did you see Mr. Cummings sign the document?
Yes.
That's important.
And the signature on what's been marked as Exhibit 1, Mr. Cummings' signature, that appears to be Mr. Cummings' signature to you. Do you have it in front of you?
It is.
Thank you.
Yes, ma'am.
Do you know his signature?
When did you sign the document?
I don't recall, ma'am.
But you did sign the document?
Yes.
Did you, who handed you the document?
The secretary.
And did you, Hunter Ashley was next to you?
Yes, ma'am.
Did he sign as well?
Yes, ma'am.
You saw him sign?
Mm-hmm.
And where was he in relation to you?
To my right side, I believe, at the table.
And this document that's been marked as Exhibit 1 was the only document that you signed. Is that correct?
Yes, that I recall.
At the time on this date that Mr. Cummings signed the will, did he seem to be in good health?
Yes.
Did he understand what he was doing?
Oh, yes.
He had a clear mental state.
Yes, ma'am.
He knew who his family was and
Yes.
what his assets were.
Yes, ma'am.
Those are my questions.
Thank you, sir. You may step down. Do you have any other proof?
I'd call Stephanie Burney, please. Stephanie Hensley Burney, excuse me.
No cross-examination from prosecution or from the other counsel. This must be the secretary. She's going to remember everything. Okay, first of all, she's a woman. Women seem to have better memories than men, and she's going to have every detail. She's like, "Yep, they used the good pen."
You please step around here and raise your right hand and face our clerk.
So there had been a notary. The lawyer was probably a notary. Actually, bring that back.
Can you state your name for the court, please?
Yes, ma'am. Stephanie Hensley Burney.
And where do you live?
Live in McEwen, Tennessee.
You were Judge Jackson's longtime legal assistant, is that
Yes,
correct?
ma'am.
How long did you do that?
A little over 12 years, 12 years and 3 months before he passed.
Oh, man.
Did you assist him in the execution of wills for his clients?
Yes, ma'am.
Do you know how many times you did that?
Over the course of 12 plus years, probably 100, if not more.
And what was your role?
He would dictate, I would draft them, I would go over them with the clients to make sure that they were accurate and see if I need to make any changes, any clerical errors. And then I would actually witness, as a notary public, the execution of the wills.
How long have you served as a notary?
12 years as well, a little over 12 years. July of 2012 is when I was first commissioned.
And have you ever had any issue with your notary?
No, ma'am.
No claim that you've ever improperly
No, ma'am.
notarized?
No, ma'am. Just renewed it in this July.
And you use a notary book?
Yes, ma'am.
You brought it with you
I
today?
have it with me. Yes, ma'am.
All right. I'm going to show you something first. It's been previously marked as Exhibit 1.
Love this courtroom for the intricate woodwork. It's not intricate like detail, but it's
Do you
just.
recognize that document?
Yes, ma'am.
Okay, what is that?
This is the last will and testament of Mr. Willard Nelson Cummings.
And did you know Mr. Cummings?
Yes, ma'am.
How did you know him?
We had handled legal matters for him for probably a year and a half at the time of the signing of the will. We did evictions for him for the real estate properties that he did. We had also done private real estate transaction for him and a sale of some real estate. So we had done quite a bit of business for him.
And Mr. Jackson prepared this will at Mr. Cummings' request?
Yes, ma'am.
And did you prepare the office and the will for the execution of the will?
Yes, ma'am.
What did you do?
I have all of the ink pen. In his office, there was a conference room table with 3 chairs. And so I would have the blue ink pens set up at each of the chairs so that the 2 witnesses and the testator could execute it. And then I would actually hand the paperwork to the client. And then Mr. Jackson would take it from there.
I called this. She has every detail.
Did you kind of have a routine or a set pattern that you would follow with Mr.
Yes, ma'am.
Jackson?
Yes, ma'am.
Was it the same just about every time?
Every time, yes, ma'am.
Was there anything different or unique about what happened with Mr. Cummings' will?
No, ma'am.
And I'm going to ask you to turn to page 3.
Okay.
Is that your signature at the bottom?
Yes, ma'am.
In your capacity as a notary?
Yes, ma'am.
Bless you.
Do you have a recollection of the day that this will was executed?
Yes, ma'am, I do.
All right. Tell me about who, I guess start with who arrived to the office first.
Okay, Mr. Bill, we called him Mr. Bill.
Right.
He showed up first, and I gave him the draft of the will so that he could review it to make sure I hadn't made any clerical errors or anything. And then the 2 witnesses showed up together. They had come from his transmission shop where they were working. And then I led all of them into Mr. Jackson's office and seated Mr. Bill at the head of the table, the 2 witnesses at the side where all of their ink pens were. I got the photo IDs from the witnesses, verified that they were the people that were standing in front of me, verified their ages, made a note in my notary book of their information. And then Mr. Jackson asked Mr. Bill, are we here today, for your last will and testament? Is this your will? Have you had a chance to read it? Are these your wishes? Are you doing this by force? Is anyone forcing you to do it? The same standard questions that he asked for all of our will executions. And after Mr. Bill had answered the questions, Mr. Jackson showed him where to execute, all of the places to sign, and then it passed down to the first witness, then to the second witness. After they had executed their parts, they handed everything back to me. I executed it, stamped it with my notary, gave their photo IDs back to them, and then they left. They had to get back to the shop, and Mr. Jackson finished up with Mr. Bill, just asking him how many copies he needed of it. And we kept a copy at the office. He took the original, and I can't remember if he had me make additional copies or not, but that's my standard practice, was just to offer. Then I went back to my office, and they stayed in there and talked for a little while longer.
So in the sequence of who signs, who signed first?
Mr. Bill did.
Okay. Mr. Cummings?
Mr. Cummings, I'm
Okay.
sorry.
No,
Yes,
that's
Mr.
okay.
Cummings signed.
And then and then the will was passed to the witnesses.
She remembers them arriving differently. The bill came
and
first.
Were they all at the same table?
Yes, ma'am.
It was a conference room table?
Yes, ma'am.
Videotape the whole thing. There's one way. Keep the evidence, preserve it.
Thank you.
You've been handed a document. Do you recognize what that is?
Yes, ma'am. It's a page from my notary book from the day of the execution of the will.
So it's a copy from
A copy
that-
from my notary book. Yes,
Okay.
ma'am.
And then the names of the other folks that are in your book have been redacted.
Yes, ma'am.
Okay. Is that a fair representation, with the exception of the redactions, of what your notary book looks like from September 21st, 2015? I'm sorry. I got that
September
backwards.
15th, 2021. Yes, sir. Yeah, yes, ma'am.
Okay. I'd like to make that the next exhibit, please. Exhibit 2.
What is the next exhibit? 2?
Okay, I want to hear from the other side why the children think they should get the money. There are a couple kids that are opposed
At
to
the time that
this will.
Mr. Cummings was in the office to execute the will, did he seem to be in good health?
Yes, ma'am.
Did you notice anything different or unusual about his behavior or health that day?
No, ma'am. He was the same as he had always been.
He seemed to understand what he was doing.
Oh, absolutely.
Clear. He had a clear mental
Very
state.
clear. Very, very clear.
He knew who his family was and what his assets were.
Yes, ma'am.
Those are my questions.
Any question? Thank you, ma'am. You may step down.
Thank you, Judge.
Do you have any other proof?
No, Your Honor.
All right. Proponent of the will has rested their proof. Do you have any proof you wish to offer? Based on the testimony and the evidence before me, I would find that this has been a duly executed will and therefore should be admitted to probate. The question of the contest will have to be obviously reserved, but will be admitted to probate.
Thank you, Your Honor.
There
You
goes.
Draw an order, please. Correct.
They're still going to contest it, but it's admitted to probate?
Yes, I will say that the petition was to admit it in common form, given that there had been a will contest. A notice of will contest that had already been filed. It's my understanding that the court continue to proceed in solemn form once the notice of will contest is on file. But I don't want to create any error, any issue.
I'm
around
interpreting that will be admitted in solemn form based upon the fact that a notice of contest has already been filed.
Right.
Now, the question of Ms. Franklin as the administrator, you have two motions, correct? All right. What are your
Here comes
motions?
the
I
administrator.
have motions to approve contracts for the sale of property at 105 College Street in Burns, Tennessee. I don't believe that one is opposed. And to approve the sale of real property located at 797 Sheehy Road in McEwen, Tennessee.
Those have already been ordered by the court. This is just approving the sale, correct?
Correct. You've already approved my
Sheehy
sale
Road.
of those properties, subject to court approval of the contracts.
Also known as Pronoun Street. We did cover the Sarah Boone new lawyer letter. We have not covered the random California lawyer who submitted the Constitution on Sarah Boone's behalf. That was just weird. It's in the docket. But I don't think Sarah even knew about it.
I just wanted to make sure. Notice the contest that I filed. My question I'm asking, is it going to relate to as long as it relates to the
So they're still contesting the will.
I understand. That's what I want to make sure. Notice the will contest. If Your Honor would like
Please come to the mic so we can hear this.
Well, my question was, Ms. Franklin has been serving as the administratrix of this CTA, I guess, or whatever, of this estate up to this point. And the will has now been admitted to probate. The will, and reading it on page
like a cross
1,
between a dominatrix
says, I
and an
nominate,
administrator?
constitute, and appoint my brother Michael Ray Cummings as executor. Is there any request to alter Ms. Franklin's position in this case?
No, Your Honor, there's certainly no motion before the court requesting a change, and Ms. Hassel, who represents the proposed executor under the will,
Well,
can
Ms.
certainly
Franklin's
state
been-
her position, but our proposal is that we were
And you represent the beneficiary of the will, which is St. Jude Hospital. Right. Miss, it would seem to me if Miss St. Jude is happy to have Miss Franklin continue, and she's been the one who's done everything, the lion's share of the work, we'd be starting all over by replacing her. So unless there's some opposition, I'm going to order that she continue in that position.
Opportunity to speak with Mr. Michael Cummings, and he is in agreement with the status quo.
She's done an exemplary job with it so far, so we'll hope that that will continue. So, all right. Thank you. And in your order admitting it to probate, would you please specify that we specifically addressed Ms. Franklin's position and that ordered that she would continue as the, I guess it would be the executor CTA or whatever. So, all right. Thank you. And I've just signed these 2 orders.
Mel, I think spell check got you, but you're basically saying when your mom passed your sister, you're cleaning out the attic and you found your sister's birth certificate that shows she was 2 years older than she thought she was. That is crazy. That's crazy, Mel.
Your Honor, we're here today on the reset of Ms. Hendrickson's motion to dissolve the order of protection. I've also filed a motion to allow for the children's testimony. I am not well today, Your Honor. I'm not sure what's wrong with me. I've put on the mask because Mr. Hawley told me he'd had COVID last week. I'm here because of the nature of the case and in an effort to try and settle it. Ms. Hendrickson and I have had an opportunity to talk about a possible settlement offer. If I could have an opportunity to discuss that with my client. If that offer is not accepted, Your Honor, however, I am requesting a continuance because...
Well, I appreciate the fact that you may be unwell and that you're wearing a mask today. I am scheduled for surgery on the 5th of September, which is next Thursday. It's going to be significant surgery, and I'm trying to avoid people who are ill for that reason. So if you are not able to resolve it, I'm going to reset your case for my own personal health and safety. So we'll give you an opportunity. We'll pass it. If for some reason that does not work, then you can't get it resolved, then get with the clerk and she'll give you an alternative date. So.
Thank you, Your Honor.
Now get out of my courtroom.
We're going to take our mid-morning
Don't
recess. We'll
Don't
be
cough.
recessed for 15 minutes.
Okay, we're going to jump back over to Judge Cedric Simpson. I think we've found the point where Amber says this is what we needed to watch today.
Farms versus Elise Liu.
If not, it might be a little after this point. It might have a few minutes.
Elise Liu, not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,967.75, cost of $189 for a total due of $2,156.75. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Is Makisha her own
Judgment to the
background?
plaintiff by default for possession, redemption amount, and the amount requested, writ to issue in 10 days. Scio Farms versus Joan Raymond.
I think Makisha is her own background.
William Raymond.
I do not.
She's here twice.
Raymonds, they're not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,951.11, cost of $228 for a total due of $2,179.11. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue 10 days. Sile Farms versus Elizabeth Sayas.
And Your Honor, this is a dismissal. We'll be
That's a
submitting an
dismissal,
order.
Sayas?
Yeah.
All right. Case is dismissed. That's without prejudice. Sile Farms versus Teresa Tomasi.
You're muted, Teresa.
Hi,
Hi.
I'm here.
Okay, hello.
Hi.
All right. Okay. How much is owing?
With costs, Your Honor, $2,191.25.
Okay.
Ann Arbor,
Ma'am.
I got an email this morning from the Housing Commission, and SIO should too, that they're going to send that money next week. I got lucky. I got some of it.
Okay, so they were going to pay. You got an email this morning saying Housing Commission was going to pay that.
Yeah, from Stacy Vincent. Yeah, I can, and she said I can just to let you guys know that, and SIO should have an email at some point today with that too.
So
I've not watched that yet.
What happens with your September rent? Do you know?
They just, whatever I applied for, which was, my docket, whatever, they're only paying what I owe. I can't add on September.
No, I got you.
Yeah.
Okay. But the problem is, if I adjourn this, September becomes due.
Oh, right. No, I've got money for September. I'm working. I just got behind.
Gotcha. Okay, you fell behind. I got it.
We're a few
Okay,
minutes.
so let me ask you this. If
away
they
from
get
the
the check
spicy one.
out,
We're just warming up.
if I adjourn this out to the 6th, are you going to be able to get September in by then, or?
Well, I've also got my SER app that I did this morning, which can give me 14 days, I believe, too. I can give you that tracking number for my SER application.
Okay. Well, what you have to do is you have to fill out a form. You can either use the QR code on the screen, which will take you to the form that needs to be with the court.
Welcome, Miss Mimi.
You have to file that by Wednesday of next week. Or in the chat, there is also the link.
I would say, I don't see any QR code. Is there any just
okay, you're on a phone, so you'll have to swipe across until you see a QR code.
Swipe,
right,
swipe,
hold on.
swipe.
Yeah, I guess I'm not very good at this.
It's just this.
Is there just
So
maybe an
in
email?
the chat, there's
Tinder.
also the form, or you can come to the courthouse, fill out the form, and
Okay.
get it into us.
That might be-
Okay?
Okay.
So what I will do is I'll adjourn this out 1 week. We'll see where we are and try to get this all cleared up. September 6th, 2024 at
2 p.m.
2 p.m.
We're waiting for iPad 1 name that case to be called. It's coming up here in just a minute.
Okay.
Thank you.
Yeah, thanks.
Sile Farms versus Danielle Williams. And
see you, Teresa.
Daniel Bleth. Either party here, they are not here. Ms. Thornley, you may proceed.
Attorney
Thank you, Your Honor. There's rent to retain of $1,970.44, cost of $228 for a total due of $2,198.44. We'd ask for a default possession only judgment with writ to issue after 10 days.
Thank you, AZ.
Judgment to the plaintiff. That's by default for possession, redemption amount, any amount requested, writ to issue 10 days. Valley Ranch versus Makisha Baines.
Here's Makisha twice.
Hi.
Oh, there she is. Okay.
Twice. Just like I didn't see you there.
There's Ms. Baines. All right. I guess I should say hi. Ms. Dornbush, how much is owing on this?
With costs, Your Honor, $1,765.29. And it looks like we did receive verification that the Ann Arbor Housing Commission is assisting Ms. Baines with some or all of that balance. We received that notification on,
Leon Brown's getting
looks like the 16th.
dressed still.
With the expectation that payment would be coming within 5 to 10 business days. I don't see it on the ledger yet, though.
Got it. And Ms. Baines, that's what you know also, right?
Yes, I called the City of Ann Arbor Housing Commission, and like this young lady stated, everything was approved on 8/16 for the emergency rental assistance. And the young lady, I called back because my front office stated they hadn't received the check, but I did receive an email saying that everything was approved and sent over to the county department, and a check will be issued to my front office. That was on 8/19, and they told me to
deep breath.
Basically. That's all I received, all information I received to pay for or take care of August. And like everyone else, I applied for the CER information. So I have all those numbers as well. But yeah, everything was approved
so
on
here's what you need to do. Is use the form. If you can see the QR code on the screen, you can use the QR code, or you can use the chat. It's in the chat. There's a link that will send you to the form. Court needs to have that by Wednesday.
Okay.
And how were you going to try to take care of September rent? Do you know?
Well, it depends on this other resource at this particular time for September.
Gotcha. Okay. No, that's fair. I gotcha.
Yeah.
So here's what I'll do.
Okay.
I will adjourn your case out 1 week.
Okay.
And
the code's like a Venmo. It's like,
at 2 p.m.
You can
so
Venmo the
September
court.
6th, 2 p.m. Okay.
September 6th,
Ma'am, how many people are in your household?
For me, just me.
Just the two of us.
Okay.
Just the two of
so
me.
that you know, if you do the SER, state emergency relief, that's going to only be about $400. Okay.
Yeah, I've already did that. They denied me.
They did not. Okay. All right.
Yeah.
So you're looking elsewhere. All right.
Yeah.
I got you.
Yeah.
Okay. Fantastic. All right. We'll see you next week.
All right. Thank you so much.
We did cover the letter from Sarah Boone earlier.
Valley Ranch.
About half an hour into the stream.
Elizabeth Wasanova.
Here we go. Is that iPad?
I was trying to get off mute. Hi, Your Honor.
Hello. I knew it had to be you because there's a lot of letters. All right. What are we, how much is owing?
With costs, Your Honor, $2,630.04.
Fun fact, she's on the other seat with Attorney Tom to her right.
And ma'am, how were you intending on getting that paid?
So I dropped off a cashier's check for $2,400 this morning at about 9:35 this morning. They weren't open yet, but I handed it to somebody in their office. And then when I talked to them, I asked them if it would be okay to do September and the remaining balance by the 13th of September, and they said that that's up to the court. So
they told you it's up to the court?
Yep.
Okay, and so then when I do something, Dornbush is going to object, and then it's just, I don't know why is everybody putting me in this difficult position? All right. So you paid the $2,400 today. Yeah. Okay, so you're about $230 short. How much is your monthly rent?
It's $2,200 with my pet rent. I think about $2,200.
Okay.
Look here, Judge. That looks real close. So, I mean.
Okay. So between now and the 13th, what would you be paying?
So I wasn't.
Or is that your next check?
That's my next paycheck for one job, and then I'm not sure what the paycheck will be for my second job yet. Yeah. Which would be the Friday in between, but I wasn't planning on paying anything until the 13th.
That's a lot of money.
Got it.
$2,200. That's a ton of rent.
Ms. Dornbush, is there any way, I mean, I'm inclined to adjourn it out to the 13th, maybe even over your objection, but I just want to verify that the 24 has been received. So if I pass it, is there a way to connect with them to?
I'll verify. I'll see if I can, well,
Okay.
let me say, I'll see if I can verify. So I'm happy to pass on.
No, I got you.
And
I got
check in
you.
with them.
Let's just try to take a shot and see what we can do. So rather than come back in between. So if you hold on the line, I'll pass that case and we'll see what can happen on that.
Here we go. Buckle up, guys.
Valley Ranch versus Lauren Victor.
Good morning, Judge.
Hello, Ms. Victor. Okay.
Cost, Judge, is $2,346.32.
2,346. And how many cents? I'm sorry.
32.
32.
Don't
All
forget
right.
the pennies.
Ms. Victor, how are you going to get that paid?
Yes, sir. So on the 6th is when I will get another paycheck so that I will have 2,136 on the 6th.
Next one.
And September's rent will be paid the following Friday, the 13th.
All right. So you can pay 2136 by the 6th.
Correct. Yes, sir.
All right. Can you get that in before, what time is those? 2?
Yes.
Can you get that in the morning?
Absolutely. Well, they close at 10, but I'm sorry, they open at 10.
Pardon?
But the office, I believe they open at 10, but I'm more than happy to do that before. I'll get it by 8 a.m. No problem.
Okay. So if you can get that in, I'll just indicate you're going to pay that by the 6th. Then that won't quite cover everything, but then we can work out where we're going to head with it. So I'll adjourn this out 1 week.
We covered this morning, but
6th,
yes.
2024 at
Yes, she has a lawyer.
2 p.m. Get
you.
that in to them, and then we'll figure out how we're going to get September done. Okay?
Yes, sir. Appreciate it.
All right. Thank you. Have a great weekend.
You do the same.
And then,
Happy birthday, Noreen.
This is Rental Management versus Marie Robinson. Sile Farms versus Kevin Berkshire. Sile Farms versus Carol Chenault. Sile Farms versus Bridget Long. Those matters are dismissed on plaintiff's motion without prejudice. Is that it for?
It is aside from the one.
In the recall. Okay. Let me know when and we'll get you right called and get you out of here.
Thank you,
Okay.
Judge.
Meta Engineering versus Robin Freeman.
Not this
Morning,
one
Honor.
either.
Tom Pietrowski on behalf of plaintiff.
I'm here, Your Honor.
Okay. Do you have a camera, ma'am?
It's broken. Sorry.
Okay. All right. Okay, Mr. Pietrowski, how much is owing on this?
Rent plus water plus court costs, $8,076. That's 8076.
Whoa.
Freeman, how are you intending on getting that paid?
Well, first off, I think the numbers are wrong. I'm looking at and another thing, I didn't get this form or this paperwork until yesterday. They served it to my child, and he never gave it to me. He's 10 years old. So I didn't even get this paperwork and know that I had court till about last night or the night before last. So I wasn't able to even start looking through SOS or Hawk yet. But that's what I was
Okay, so here's what you need to do. If you're going to call Hawk, you need to call them. If you're going to do an SCR, you need to file it, get the tracking number. On your phone, there is a QR code, as well as if you look in the chat, there'll be a link to get the proper form to fill out with the court. That form needs to be into the court by next Wednesday.
Okay.
And what I will do is I will adjourn the matter out to September 6, 2024 at 3 p.m.
Yeah, could I ask the court for could I ask the court for the 13th, Your Honor? Only because I have a conflict.
Okay. I don't have a problem.
Thank you, sir.
But still, I will need to bring the paperwork on Wednesday still.
You still have to do everything by Wednesday. So
Okay.
I'll go to September 13th, 2024 at what time? 12 p.m. At 12 p.m.
12 p.m. Okay, thank you, Your Honor.
Thank you.
Thank you, Your Honor. Have a good weekend.
Thank you. You do the same, sir.
Thank you.
And go Terps. I know that will upset you. Don't worry about it. Just thought I needed to tell you.
I'm sorry. You went foggy on me, sir. I didn't hear you.
I'm sure I did. Take care,
Bye
sir.
now. Yes, sir.
Lisa Reppert versus Leon Brown and Melinda Brown.
Yes, ma'am. Or I'm sorry, Your Honor.
It's okay.
I'm Lisa Reppert.
Okay.
Yes,
That's an
ma'am.
unnamed iPad. That's Ms. Reppert. And I see Leon Brown. You're at the 14A. You're in Saline.
Yes.
Okay, sir, you need to unmute, Mr. Brown.
No, that doesn't mean talk louder. You have to push the button.
We're sending a clerk in to help you unmute, okay?
Oh, he's in court. They can help. Please hold. We need some hold music. Please hold.
Oh, can you hear us, Mr. Brown?
Okay.
It's muted.
Hear it? No.
Yes.
Go ahead and just start talking. Okay, we can hear you now.
Okay, yes, I'm Leon Brown. I have a letter from my wife with power of attorney. She has my 2-year-old grandson right now. She signed and dated it.
Okay, you're good.
Okay.
And I take it that is Melinda Brown is your wife?
Yes.
Okay. All right, real good. Okay, this is a termination of tenancy claim.
They're trying to kick out the tenants.
And I guess, was there a...
I'm going to be up here for this one.
Was there a lease on this premises?
Yes.
There was no written lease. There was an oral agreement.
Your Honor, I have a problem with that because I signed a 5-year lease with option to buy. My wife's a pet groomer and she got a percentage of the grooming, and we were going to open boarding for dogs and she was going to get a percentage of that. I signed for me and my wife and she signed and dated it, but she didn't give me a copy of it. So now she's lying that there wasn't one. And at the beginning, I told her I could not rent a place like that because I needed to move her out, move us in, redo everything. And I couldn't rent because I couldn't do all that work and then have to move in a month or whatever. So we did a lease agreement on paper that she didn't give me a copy of. That's what she's going off of now, that the person that I signed this with isn't her. It's all been lies and fraud, my whole tenancy. And I got a...
Okay, hold on.
Okay.
Wow.
So I didn't even know if this was real. I didn't even know if this was real, if it was fraud.
Okay, so hold on. To the records, are you claiming rent or you want possession of the premises?
Possession of the premises, order of eviction, and money damages.
Okay.
And Your Honor, in relation to the lease that Leon is talking about, he has a propensity to exaggerate and distort and claim things at a much later date.
All right. We can stop that now because I'll just assume everybody's a liar and we'll go there. Okay? So we'll just work from that perspective. I'm not going to listen to all of that. I'm looking to make sure that all of the paperwork. Okay. So there's a problem here. The notice the notice to quit that you given the court or that was served on them on July 8th, or so it says. Is a non-payment saying that they owe $1,500.
That's correct. In addition, he owes consumers, propane.
Okay. All right. But then
okay.
I have another notice, but I don't have the court copy. I have another notice saying that you're terminating his tenancy, but I don't have the court's copy.
But he has a copy.
That would tell me how long a period in time you gave him. But regardless of that, I then have a health hazard. What are you? That was served on 7/25. All right. And then the only complaint I have is a termination of tenancy complaint. But I don't have a proper notice in the file.
A notice for what, Your Honor?
Termination.
There was a 30-day notice to quit that was sent on June 20th, 2024. There was a 7-day.
June 20th.
Yes, sir.
It was a letter.
I don't have that.
That was filed.
It was filed with the complaint.
Okay, I'm going to tell you what I've got because you've got a lot of paper in here, most of it unnecessary. I have a demand for possession, non-payment of rent that was served on July 8th, purportedly served on July 8th to Mr. and Mrs. Brown. That's a 7-day notice for non-payment. That says he owes $1,500. There's then a lot of other paperwork, not a statutory notice. I then have a demand for possession, termination of tenancy due to unlawful drug activity.
Whoa.
That was served on July 31st. I have nothing to indicate any drug activity, but whatever.
I have exhibits that I can show you.
Ma'am, you're telling me what I have in my file. I'm letting you know what I have in my file. So I have those two notices. I then have another notice. This is crazy. Demand for possession, damage, health hazard to premises, which was served on 7/25. So I have that notice. I then have, along with a bunch of other paperwork, I then have another notice that indicates that it was served on June 20th, saying that they had to move by August 3rd at 5 p.m.
That's the 30-day notice.
That's the 30-day notice.
That was supposedly served by first-class mail on June 20th.
Correct.
That's correct.
And then I have a termination case. So I have all of these conflicting notices.
Okay.
So which one are you trying to proceed on?
I want the judgment of possession. I want the termination of tenancy, order of eviction with money damages.
Oh my God. Okay. That was not an answer to my question.
I'm sorry.
Here's the thing. I'm going to.
Your Honor, can I speak?
No.
Okay.
Because right now, this paperwork is all a mess. Because I have a non-payment of rent. I've got all of those other notices in. Even if I ignore all of those other notices, and I'm not sure that I can because they overlap, I then have a termination of tenancy that it's terminated, claiming that he's a trespasser, which I don't know how that would even be applicable. But then I have terminated by notice to quit, and I presume you're going on the June 20th notice to quit. But he's saying he's got a lease.
Your Honor, if I may interject.
Who are you?
Pardon me?
Who are you?
Okay, I'm her father. I'm the one that delivered the papers to Celine, and I delivered the papers. They were date stamped on July 13th. At that time, there was a big stack of papers. There was a complaint filed for non-payment of rent. There was a complaint filed for damage to the property. And there was a complaint filed for recovery of possession. Approximately a few days later, my daughter got a call. She was in Nashville, that the paperwork was filed wrong. And so she asked me, since I live in Toledo, to go down there and straighten it out for her. When I went there, they told me I had too much paperwork, that I didn't need the complaint form for the non-payment of rent and for the complaint also for damages to the property. So I had to rip those out. And the clerk there said the exhibits or the attachments that we had to the complaint for recovery of possession would be satisfactory. Concerning those different terminations, he was given a 30-day notice on...
Sir, I have no idea what the clerks may have told you.
You have no idea what?
I don't have any of that stuff.
Well,
what
Your Honor,
I have is a complaint for termination of tenancy. That's the only complaint I have.
Okay. And I have copies of the original complaint that it contained all three.
I don't know how you would do all three, but okay. The only one that I have is a termination of tenancy.
Well, that's the most important.
Your Honor, can I speak?
Go ahead. Briefly.
I have already been forcefully terminated. They have came to my house uninvited, arguments after arguments, traumatized my grandson, my daughter. My son is mentally ill, under treatment. He just got dropped off at the house by the state of Michigan, DHS, and they had the driveway blocked and the house wide open. And it has been a nightmare. And I've been out since July 29th. I've been out of there, but I've been trying to recuperate my property. But I can't do that because I keep having them pull in uninvited. You're supposed to have a 24-hour notice. I've had the...
Why are you going to the property?
Because the grass has not been cut. I'm getting complaints from the township and the neighbors about the amount of junk that's being dumped on the land, the amount of boats that were stored on the land.
The amounts of boats.
And
whole fleet.
He had stopped cutting the grass. So that's why we went onto the property to get the grass cut.
Did you block the driveway?
No. It's a huge driveway.
It was blocked, Your Honor. My son is mentally ill. The Department of Health and Human Services had to take him to a gas station where I could pick him up because he was scared to go there. I mean, he's really under intensive care. And this is all a smoke screen because she's committed fraud with the banks and was using that.
Objection, Your Honor.
Was using that.
First of all, that's irrelevant to an eviction.
Your Honor,
objection relevance?
She's got problems with the bank. They wouldn't accept my payment. They wouldn't accept my payment or let me open an escrow account because of her fraud.
Objection, Your Honor. That's completely false.
Were you there? Were you there?
I'm sorry, this is the case where the attorney reached out from like out of state asking you. This is that case. So my understanding is they weren't talking to an attorney.
Who?
Last name was Sanders.
Who was talking to him?
I believe it was something like that.
Clerk says, Judge, this is that one case we
Is
talked
having
about.
an attorney represent them?
We received an email from this person.
I don't have anything.
House. I was just
Okay. Oh, that's the one. Okay. All right, folks.
Here's what we're going to do.
So I have already been evicted. I will not step foot back on the property.
Well, they're claiming a whole lot more, so I don't know what's going on. I'm going to set it for a final settlement conference, September 10th, 2024 at 9 a.m. at the 14A1 location. Everybody needs to be here in person.
Your Honor, can I have time? Can I have time to get an attorney? Because
you have time. You have time, sir. You can get an attorney anytime between now and the 10th.
She's using her father as an attorney, and I believe that he doesn't have a license.
Okay. Well,
Your Honor, if I may speak, I'm her father. I am an attorney. I am licensed to practice in Ohio. I did make an attempt to get temporary admission to practice in the state of Michigan. I had a sponsoring attorney lined up. At the last minute, he backed out. I tried to find another sponsoring attorney. I called the economic disaster unit or recovery unit.
Sir, we received all of that information.
Okay.
You can't proceed as a licensed attorney without temporary admission. They gave you the process by which you'd have to do that.
That's right.
That's right. So I am acting pro se, and my father is here as my agent and my witness.
Okay. You guys like to use a lot of big legal words and have no idea what they mean. So here's what's going to happen. Understand this. Everybody needs to be in my courtroom September 10th, 9 a.m. in person.
We need to be there.
Sir, if you want to get an attorney, you have plenty of time between now and then to get an attorney to represent you on the matter.
Thank you so much, Your Honor.
Amber, put this on the calendar.
Thank you, folks. September 10th, 9 a.m.
Wow.
Can I just say that I have been evicted and I will not be back at the property?
Well, I don't know what you're saying. All I'm saying is I'm not making any ruling. Everybody needs to be here September 10th, 9 a.m. Anybody got anything else? You really probably don't want to say anything else.
Thank you so much, Your Honor.
Great. Everybody have a wonderful holiday. We'll see you on the 10th.
Thank you.
Wow.
Yes.
Wow.
Court recalls the case. Valley
What did she
Ranch
just mouth?
versus Van
Stop.
Wassanova.
What did she just say?
The record, Your Honor, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, I was able to confirm with my client receipt of that $2,400 payment.
Full stop. Full stop.
Okay, great. Then what?
Let's
And
just
you're not,
rewind.
Ms.
Just,
Van
just a
Wassanova,
teensy,
you're not
teensy bit. Okay. I want to watch the lady in the bottom left-hand corner and see what her mouth says. And somebody do some lip reading
Anything
for
else?
me.
Thank you so much, Your Honor.
Great. Everybody have a wonderful holiday. We'll see you on the 10th.
Thank you.
Yes. Court recalls the case Valley Ranch versus Van Wassanova.
Oh, what did she just mouth?
The record, Your Honor, Rachel
That was not a
Garnley-Kellis
thank
on
you.
behalf of the plaintiff. Your Honor, I was able to confirm with my client receipt of that $2,400 payment.
Okay, great.
That looked like my trees. That's what it looked like. Whoa, and it's on record. That was an FU. That was an FU if I've ever seen one in court. Whoa. It was the French version of thank you. Yeah, no, that was not merci beaucoup either. No, that was it. The way it was out the side of the mouth. Oh my goodness. Oh man. It's going to be great. September 10th. You guys, we've got a case to watch on September 10th. It's going to be in person. Let me jump back to our Heavenly Wood court. Where they got back off break. We're going to rejoin them and see what spiciness is going on down here. Or maybe something sweet. Maybe it'll be like a nice adoption or something where we can just have a feel-good factor. Welcome back, Judge. Sorry to hear about your shoulder, by the way.
The next case.
Kerrville. That's 100% an FU coming from a near-death lip reader for life. Yes. I caught that out of the corner of my eyes. She said, what? She said, what?
What?
It's already on the calendar. Thank you, Amber. Remind me.
This originated as a complaint to establish parentage filed by the District Attorney's Child Support Office, if I understand correctly.
Yes.
And paternity having been established, this is a motion to set visitation. You are Amy Susan Hewitt. Ms. Hewitt, you understand why we're here today?
Yes, and I would like to get a GAL or a CASA advocate for my case and request that before making any determination, the court review his criminal record, request a record of any child protective investigations, and that he's been involved with, and require he take a drug screen.
Well, first and foremost, let me tell you that there's a motion that has been filed to set visitation, and that motion was set for hearing today. You have not yet filed any sort of response to that motion as far as this record reflects. Have you filed anything in writing?
I don't have an attorney.
Yes, ma'am, I understand that. The child support DA is not going to represent you on this matter because that's not their job. They only handle the child support action. But you have the right to hire an attorney of your own choosing if you choose to do so. The question is whether or not you are planning to do that.
Told to ask for guardian ad litem.
A guardian ad litem. Guardian ad litems are not automatically awarded because of the simple fact that if I appoint a guardian ad litem, there has to be, number one, a valid basis for the appointment of a guardian ad litem. Number two, it has to do with who is going to pay for the guardian ad litem's fees. They don't do it for free. Usually there's an attorney that's appointed, and that attorney expects to be paid according to that. And in a civil case, most of the time the guardian ad litem is paid by either one or both of the parties. So it would be an expense to you and to Mr. Fenton. So paternity was just established in May of this year.
This is a who's the daddy case.
According to the file, it says that on May 20th of 2024, court held that the father was the biological father of the minor child. Well, I cannot, simply because you asked me to appoint a guardian ad litem. Now, as far as the CASA, you have every right if that's what you choose to do, but that is not something that the court normally orders as well. You have opposition to Mr. Fenton having visitation with a minor child?
He's 3 years old.
We can't hear her.
I'll let him come around to the side a couple times. Over, he lives out of state.
Well, here's what we're going to do. We're going to conduct a hearing of sorts, and I'm going to hear from him about what he's asking me to do, and because he set this motion, and then I'll hear from you about what your reasons are. What you're stating is really testimony, and I need that to be under oath. So we'll have this hearing, and then when I've had the hearing, I'll make a decision on what, if any, visitation or what, whether to appoint a guardian ad litem at that point, okay? All right, just have a seat at that table, please. All right, Mr. Murphy, you wish to put on proof?
Yes, Your Honor. We would call our client, Matthew Fenton.
Mr. Fenton, step around, please, and have a seat in the witness stand.
Yeah, good. We're going to be able to hear this. Mr. Murphy's super excited to bring this issue to the court.
Could you please state and spell your full name for the record?
Matthew Christopher Fenton, MATTHEWFENTON.
And Mr. Fenton, are you the co-parent? Are you a co-parent of Amy Susan Hewitt?
Yes, sir.
Both of you have a child together?
Yes, sir.
How old is the child?
He turned 3 February 28.
And you're here today because you would like to begin visitation with the child. Is that correct?
Yes, sir.
Okay. Have you made any?
You're going to have to speak into that microphone a little bit more.
Yes, sir.
Have you made any efforts thus far to get visitation?
Yes. She allowed me to come on 3 visits.
Who is she?
Miss Hewitt allowed me to come 3 different times after March 25th when I was, I'd taken a DNA test. And I went to her house after 12 noon, and I stayed until 7 2 times, and then the 3rd time I stayed until 9 p.m. My mom, it's just turned 82 years old. She went twice. That's the only 2 times she's ever seen him. And
23 hours of
we
visitation.
just would like rights. I was never told the truth. I was told that it was another man's child, that she had DNA tested the father. I came in when he was born, or when his expected date was February 24th, 2021. I was working in Virginia, and I drove in from out of state 8 hours away, and Miss Hewitt told me that it was not my child, that she had DNA tested the father, that it had nothing to do with me. I never heard anything back, and I don't know. I believed her. I've never had a child before. This is my only child. And I'd just like to, be involved in his life and get to visit him.
Has Miss Hewitt refused you visitation at any point?
Yes, sir.
Tell us about that.
I went 3 times. Well, we had the court hearing, and it said on the documents that you have there, Mr. Wolf signed off that I should receive reasonable visitation. And I highlighted it and sent a copy to Miss Hewitt and asked her for visitation. I even really wanted to get him for Father's Day, because I'd already missed a few. And I drove down and went to the district attorney's office that day and spoke with the child support lady as well. And, she told me to contact my attorney, and then I came on to the courthouse. But yeah, she will not allow me to see him, and told me not to come back to her house. And that pretty much happened when I filed for visitation rights.
Did you advise her that was part of the court order?
Yes, sir.
Looks like alternate residential parent, non-custodial parents will have reasonable visitation privileges. Did you tell her about that?
Yes, sir.
What was her response?
She doesn't care.
And you did give her a copy of that?
Yes, sir.
Okay. You just heard her make some claims just now when she appeared up here at the podium about criminal charges and all sorts of other things. Do you have any kind of response to that?
Yeah, I don't have a criminal record. I've worked on federal projects for the last 23 years since I was 18. I'm currently doing a Send Elements battery recycling facility, which is government-backed and is a federal project. I take random drug tests and more than happy to take one right now today in court. And
I would do it in the bathroom, maybe.
I don't even have a bad driving record. Nothing's on that as well. So.
Where do you live at?
I live in Scottsville, Kentucky for the last 16 years, it'll be 17 years in April of next year.
Okay, so just from a, just so we just understand how this would work, how would you propose, visitation work if you being out of Kentucky and her being here in Tennessee?
I'm more than happy to make the drive to come pick my son up and drop him back off, just whatever it takes to see my son.
You just want to start seeing your son again?
Yes, sir.
Okay. Let me ask you this. Have you taken a parenting class recently?
Yes, sir.
Judge Boyd certified.
I have a completion, but it's on my phone. I don't have it printed off. But
You don't have a physical copy, but you did complete it?
Yes, sir. And
This morning?
I emailed it to you as well. So we can get that,
So you'd be happy to late file it if we have to?
Yes, sir.
Okay. All right.
Took a parenting class this morning?
Those were all my questions. Thank you very much, Mr. Fenton.
Hewitt, you are representing yourself at this hearing. You have the right to ask questions of this witness. I'm going to give you a chance to testify if you want to testify, but do you have questions that you want to ask of this witness?
Thank you, bailiff. Thank you. Got her up.
You're
on the
not
microphone.
required to ask questions. I'm just giving you the opportunity. If you want to ask questions, they must be in question form, and it must relate to some issue that's before the court. Do you want to ask him any questions about what he's testified to?
I gave you time with Ashton supervised at my house, right?
I took him every time that I was there, and your daughter.
And supervising with your mom.
No, I mean, the first time wasn't. My mom wasn't with me.
You just testified your mom came with you.
Twice.
Yeah.
The one
And
time, the first time I came alone, and I took him to the auto parts store to get parts to fix your car because it was broken down. And I came back on my first visit and fixed it so you had transportation. And then also gave her money to get insurance and to get her tags for her vehicle so they would have a reliable vehicle and transportation.
I never denied you that I seeing him at my house supervised, right?
Yeah.
I denied you.
The messages I have say not to come
I've got
back.
all of them printed out along from your ex-wife too.
Okay. I mean, I don't.
Chris,
thank you.
You shouldn't have. I don't see.
The reason is he's autistic, nonverbal. You've known about him since day one.
Number one, you're testifying now. I'm going to give you a chance
Sorry.
to testify, but you are not required. I mean, you cannot make statements and testify at this point.
Well, CPS has been involved with him in the past and his ex-wife.
And again, you're testifying, and I'm not going
I'm
to allow
sorry.
you to do
Okay.
that until you take the stand, okay?
Okay.
All right, thank you. Step down.
You're
Oh,
done.
let me ask you a couple of questions.
Yes, sir.
You're asking for visitation at this point, but in the petition that you filed, you asked to be made the primary residential parent for this child. You aware of that?
Sir.
In other words, you want to be the person who has full custody of the child and she has visitation.
Yes, sir.
Even though you've not had but 3 visits with this child since he's been born?
Well, I mean, I'd like to make up for lost time and at least have, split visitation with him where, I mean, he's taken to me very well. I mean,
No, she's made statements several times about this child having some special needs. Are you aware of any special needs that your son has?
Yeah, he's nonverbal. He doesn't speak, but I'm able to teach him stuff pretty easy.
And he's 3 years old?
Yes,
Okay.
sir.
All right. Anything further, Mr. Murphy? Thank you, sir. Step down. Mr. Murphy, you may call your next witness.
No further witnesses.
All right. Ms. Hewitt, do you want to tell me why you don't want to let him have visitation? Then come up, raise your right hand. Let's place you under oath.
She's got printouts of text messages.
He has a bad history, and I've got proof from his sister, his ex-wife.
he.
Two
Well,
different
number
people.
one, let me explain to you, this is a court of law. That means you can't just get up and say you've talked to somebody and they've told you things. You have to have those people come in as witnesses and testify themselves of their own direct knowledge. Otherwise, what they say would be considered to be hearsay.
Out of court
In other
statement.
words, we could have witnesses come in all day long and say, well, Joe Blow out here told me that the father is a terrible human being and he does this or does that. So it's not sufficient for you to bring in statements of other people who supposedly have knowledge. You would have to have some sort of testimony from them in person so that Mr. Murphy, representing your child's father, would have their opportunity to then cross-examine them to determine whether or not they're being truthful or not truthful. That's the way the system works. So.
Get in they're sealed court documents, but his ex told me she would resend them to me.
Again, Mr. Murphy's objecting to you saying what
So I
his
would need
ex-wife.
her.
When I'm talking to you, just be quiet, okay?
Sorry.
When Mr. Murphy is objecting to you saying what the ex-wife said, which is the very reason that I've explained to you, that it's considered to be hearsay, a statement by someone made outside of the court that you're bringing in to prove the truth of what's in that statement. That's classic hearsay and it's not admitted. So tell me, other than what someone told you, what knowledge do you have? First of all, what kind of relationship did you and Mr. Fenton have before you became pregnant?
I was best friends with his sister and we grew up together.
Okay.
I love his mom, love his sister. They had warned me prior. But
how long did you and Mr. Fenton have a relationship?
It was 3 months and he started acting erratic.
When you say, if you saw something that he was doing erratically, tell me what you saw that you think was erratic.
Driving crazy, screaming, scaring me and my daughter, cussing, throwing things.
And why were those things happening?
Be honest, I don't know.
Were you and he having an argument?
Not at all.
Was he under the influence of some substance? You have any knowledge of that, or are you just assuming that?
I have knowledge from being around past family members with the same issues and talking to his sister and mother and them informing me.
Again, Mr. Murphy is
sorry.
objecting, so I'm sustaining his objection. I won't allow you to testify about what they said. So you become pregnant, did that end your relationship, or did you stay together after you became pregnant?
I've got my messages in his, but he didn't want us to, he just dropped off the earth because I wouldn't uproot my children and go live in a travel trailer while he worked out of state.
So when did you and he stop having a relationship?
I was 4 months pregnant.
All right. From 4 months pregnant until March of this year, did he ever see or have any contact with this child?
No.
Okay. Did you ever refuse him to have contact
No.
with the child? Again, just wait till I'm finished. Did you ever refuse to let him have contact with your son before that March date that he's referred to?
No, sir.
Did he ever contact you before he was served with a petition to establish paternity and to set child support? Did he ever contact you and ask for visitation?
No, sir.
All right. So the first time he asked for visitation was after you and he had been to court over the child support?
Yeah, it's
All right.
about,
And then you allowed him to have supervised visitation, come into your house, being with your child, correct?
yes, and his mother.
All right. And his mother came along too?
Yes.
Is there any reason why you would not allow him to have that type of visitation right now?
I never said that I told him he could come to my house
All right.
supervised.
Tell me about your son. What issues does your son have?
He's got a rare heart condition, Epstein's anomaly, pulmonary hypertension. And then he's nonverbal autistic,
He gets therapy through the week and PK3
Where does he get therapy?
at pre-K with special services. He started at TEIS, Tennessee Early Intervention,
Okay.
from birth, and then we
She was sworn in.
moved over to with the Board of Education when he turned 3, and he goes to school during the week, and he gets OT, PT, speech, ABA.
All right. And where does he go to school?
Oakmont.
Oakmont. Now, what I'm understanding you to say is that you have concerns on what people have told you about Mr. Fenton and his past, but that you would be willing to let him have visitation at your home?
I would be willing to let him, if I was there, just not
Well, that's
him
what I'm
take.
talking
Yes,
about.
sir.
But you don't want him taking the child away at this point?
No, sir.
All right. Anything else you want to tell me about, other than what somebody may have told you? Is there anything else you want to tell me about your son?
He's
Mr.
my
Fenton?
world.
You understand that when he was held to be the father by the, when he was held to be the father by the child support magistrate, then that means he has certain rights under the law, that he has a right as a father to see this child, his son. The only question, you don't get to have it both ways. You don't get to have, for example, the child support paid but no visitation, absent a finding that he poses an immediate and serious harm, threat of harm to your son. In other words, if you establish paternity, those rights go with the child support obligation. He has a right to see the child. So the question is, do you understand he has a right as a father to visit with his son?
Yes, and I never denied him seeing him.
Okay.
And I've raised a 22-year-old with autism who's in college, successful, works at Walgreens as a pharmacy tech. I've got a 12-year-old with autism also. Like, I've done this a long time, and I've known him a long time, and he wouldn't be safe.
Mr. Murphy, you have any questions?
We lost the witness camera. You guys plug it back in. Judge running the tech in the courtroom. There we go.
Drop my pen.
Let me ask you some questions. First off, I think you made it pretty clear. You said you're not opposed to him having visitation with the child. Is that correct?
I never was. As long as it was supervised, I was there.
Okay, what exactly are your concerns as far as him being able to have the child at his house?
Number one, he's never raised a child or been in his life for 3 years. He doesn't know him. I mean, just because he puts his hands up to him, he does it to any man because he's not around men.
So how much time would you say would be needed to get to know the child before you'd be comfortable with that stage?
With him, what stage?
With him actually having a child at his house?
I don't know.
You don't know?
I mean, he's autistic and nonverbal, and I mean, he's a complete stranger.
Have you given Mr. Fenton the opportunity to assist with the child's autistic and nonverbal needs?
I was more than willing. The only reason I objected to anything was when he told me to have him ready Friday night, and then he would drop him back off on Monday. That's when I cut it off.
What do you mean that's when you cut it off?
That's when I cut off. I was like, you're not taking my child out of state that can't even tell me when something's wrong. You've never raised a child. You have no idea what this is like, much less with autism and his heart condition. He's never been a night away from me.
Okay, but I think, is there a point to where you have to understand he has parenting rights to this child just like you do, right?
Yes.
So is there a point to where you'd be willing to agree, okay, yeah, you can take him overnight?
I mean, we would have to see if it would, I don't know.
Okay. Judge, let me see if my client has any questions other than that.
Does client have some questions? He's pointing to somebody else in the courtroom. I think it's his mom.
All right, thank you, ma'am. You may step down and have
further
a seat at
questions.
the table. Mr. Murphy, do you say you have something else?
Yes, Mr.
All right.
Gonna call
Call
the
your
mom.
witness. Step right up here, please, ma'am.
She looks young. It's either his current wife, girlfriend. That can't be his mom. Yep, no, it cannot be his mom.
Could you please state and spell your full name for the record?
Elena Page Reimers, ALAINAREMERS.
Ms. Reimers, do you know Mr. Fenton?
I do.
How do you know him?
He's my mom's boyfriend.
Has he raised you at any point?
Yes.
Can you tell us a bit about that?
He's raised me since I was 12 and provided me with everything that I've needed.
Do you and him have a father-daughter relationship?
I would say so, yes.
What would you say about that experience as him acting like your father?
He's done more than what my actual father could have.
You've never seen him have any kind of drug problems or
No.
any criminal activities?
No.
Okay. All right. You think, based on what you've seen, he'd have any problem raising a 3-year-old child?
No.
Okay. Those will be all my questions, Your Honor.
You have any questions for this witness? You have a seat, please. You testified about that, but to your knowledge, has Mr. Fenton ever dealt with an autistic child that's 3 years of age that's nonverbal?
No.
Okay. Thank you. You can step down.
Judge has
Any other
concerns.
witnesses, Mr. Murphy?
The mom has some legitimate concerns acting in the
Do you have
interest
any
of the
other
child.
witnesses you wish to call?
The dad has rights.
All right, this is a temporary hearing on a motion to establish some sort of visitation. The order that established Mr. Fenton's paternity of this child was entered by the child support magistrate on May 20th of 2024. And at that time, the order that was entered was entered based on the failure of the plaintiff to appear, which was Mrs. Hewitt.
You know that's
And
nonverbal.
nonetheless, it was entered that it would be a child
with some
there would be a
other medical
establishment of paternity, and that he was found to be the father, that the primary residential parent would be the mother, and that the defendant, as the alternate residential parent, would have reasonable visitation privileges. So it has been established, and what is reasonable to one person is not always reasonable to the other, and that's one of the problems with reasonable visitation. The court finds that it is based upon the distance between these parties, that it is reasonable for Mr. Fenton to have visitation at Mrs. Hewitt's or Miss Hewitt's home for a period of noon until 9 o'clock on every Saturday. Well, we'll make it one Saturday, and then alternate week will be Sunday. And that will continue for a period of 90 days. Following that, he will have visitation consisting of all day, and it will no longer be supervised. In other words, I'm going to graduate that to, it'll go from 8 o'clock in the morning until 8 o'clock or 6 o'clock that night. And it'll be day long, and he'll be allowed at that point to remove the child. After 90 days of every week having the child visiting with the child, we'll assume that there is a problem. that there is no problem and he'd be able to have the child and go that. That's all I'm going to do on a temporary basis. That will be continuing. And he'll have that child 1 week on Saturday, 1 week on Sunday. But he'll see it weekly because I'm trying to establish a bond between him and the child. This is a difficult situation because of the child's special needs. If you want to consult the CASA people to see whether or not they can assist you in that regard, but there's no evidence before me to indicate that there is any problem with Mr. Fenton as a father. And you can expect that barring something, this will gradually increase to become a lot more like a normal visitation situation. But a lot of that depends on whether or not Mr. Fenton is able to handle dealing with this young man and whether or not the child adjusts to being away from you, and the special needs that he has are a question for the court. So I'm going to order this as a temporary basis, and then subject to review. If the parties can't work out an agreement, Mr. Murphy, you can revisit this motion. And Ms. All right, thank you. And Ms. Hewitt, if you consult with the CASA people and they are able to give you some assistance, then, we can this is a temporary order, which means it doesn't, if the child has an adverse reaction, and again, I'm going to encourage you and order as a part of this that both parties will work to encourage the visitation being as smooth and beneficial to the child and not create an environment where the child is hesitant to go with his father. So part of it's going to be your job is to try to make him comfortable with going to see his father. But if there is an issue, then it can always come back before the court, me or one of the other judges. All right, thank you.
I love seeing this. I've seen this from Judge Cedric Simpson as well as Judge Wolf in cases where especially there's a child with autism, their understanding of the need for consistency, just the additional challenges that exist. First of all, it's sad that there's a parenting and there's a fight over a child. That's terrible. It's a terrible situation.
Execute these documents when he comes out.
And best case scenario usually is not perfect for the child. But I think the judge made the right rule there. There's a trial period for the dad where he can establish that link with the son.
I will carry these documents back to be notarized.
I think it was very fair.
And we'll send them to the court.
You were going to notarize them?
Yes, Your Honor.
I think the judge acted in the best interest of the child.
And there's been modifications, so we are not going to need a final hearing. My client has already signed it and had it notarized. I'm sorry, what came up with me.
Here, y'all might want to get on this side since he's going to come out that way.
Yeah. So we have, excuse me, we have prepared, and there's been just some modifications that we have made on the day-to-day schedule. My client is relocated, and they have consented and agreed to that. There is, because of the criminal issues, he has no contact with the youngest child, Michelle, and that will continue. When he is released from incarceration, any residential time with their son, Ian, who is now 16, will be at Ian's discretion. We have him initial those as well. So again, we had put in there that due to the father's being afforded no residential time, that the
Mr.
issue
Duke, if he needs to step over to the table there, he can do that.
that he will have absolutely no residential time period with their daughter.
It's hard to sign when you've got belly shackle on.
And that's part of the terms of his sentence. But the 16-year-old will be at the child's discretion. We agree, Your Honor, that because my client is relocated, that any future modifications of child support will remain under the jurisdiction of this court here in Dickson County, so long as the father maintains a residence upon his release here in Dickson County. And if he moves from Dickson County, then under the UCCJA would kick in, and we're not waiving jurisdiction at that point in time, and the jurisdiction will go with where the children reside. And again, that's the father is, the parties sold the marital residence, and they had previously divided that money. And due to his incarceration, his previous support obligation when he was employed prior to his conviction is $1,354.17. That amount will continue. The monies that he received from the sale of the house, he has possession of those. Their oldest son, who is now an adult, has been designated as his POA, Mr. Castro's POA. that individual, that child is going to set up an automatic debit out of the father's account and debit the amount of child support directly into the mother's account so that she can continue to receive the child support and not be involved in anything directly with that. She's claiming the children as dependent. We've already done that. So
That should say
yeah, this is $1,354.17 per month. And so the remainder of the parenting plan that Mrs. Cantu signed is already there, and he is going to sign. And he is going to sign the parenting plan here in the presence of the court. Ms. Duke will then take these documents back to her office and place her seal on it, and we will bring back the final decree for your Honor's signature. And if we could.
Sounds like they have a plan.
After he gets done, just.
We'll be here, not Monday, which is Labor Day, but I'll be back Tuesday for Circuit Civil Docket Call and Chancery that afternoon, but there's nothing set, right?
Yes. I have a matter in front, I have a short matter in front of Judge Wallace that's supposed to start at 9 o'clock in Ashland City. And then I have one matter, I think one or possibly two. It's a motion to transfer and so it's set in front of you at 10:30, I think, when you're starting the Chancery docket. So I anticipate hopefully Judge Wallace will start court on time and I'll be back.
Well, the Circuit Court Civil Docket Call has got quite a few cases set, including a motion for summary judgment, which may take a while, so
Yeah, so I should
probably be all right.
And then they're also having the Stewart versus Miller case that I'll have to testify in. So hopefully I can coordinate that. But we can bring that over. I'll bring it over then if.
All right.
Trying to see if something's about to happen in Thurston County, but the stream just dropped.
Division of marital assets and debts in the marital dissolution agreement is somewhat standard and really probably no need to announce those. But Mr. Castro's reviewed this document and has agreed to it, and so has Ms. Cantu.
If we could just while they're here, if they could both be placed under oath.
Both of you, if you're able to, raise your right hand and be placed under oath.
Ms. Cantu, we have gone through this. We have prepared our resolution that we've gone over. We have stipulated the ground. And we have gone over, you have two minor children remaining. We've gone over the terms and conditions.
Mr. Castro, you signed.
Okay, I'm going to jump up to Thurston really quickly and see what's happening up here. This is sad.
And do you believe it to be an equitable division of your marital assets?
Waiting for the judge to
And you
pop in.
signed an agreed permanent parenting plan today wherein you will have, your child will have discretion over visitation with you.
Okay, here we go.
And your youngest child.
Jumping up to Thurston County, Washington, where Preston White has an advertisement of his own. He's accepting clients. Don't call unless you need his services.
Seated, please. Okay. Look at that. Mr. White's here.
How do you know it's him? Oh, the sign. I see.
Be misoriented, Mr. White?
No, I was just told that Ms. Hand's hearing was moved to this afternoon. I'm just checking some things with Mr. Thompson while he's here.
Okay. I don't see him.
Which caused him to step out of the room, so I'm sorry for interfering with the court process.
He was here, and when I left, now he's gone. Okay, who have you got here, Mr. Kale?
This is Kenneth Little, Mr. Pasturka's client.
Okay. Morning, Mr. Little. All right, Mr. Little, we're going to wait till the prosecutor gets back, and then we'll take your case.
This is a commissioner, Commissioner Paul Woll, and by consent of the parties, he acts as a judge. That's how they do it up there in Thurston. I think it's the city of Lacey, Washington, if I remember correctly. This is where he's at.
He probably just doesn't want to see me.
He doesn't want to see me.
Okay. Sort that out. Let's see who else is here.
While the judge is waiting, let me just acknowledge that several of you in chat have a lot of experience in specifically related to that last case we watched with the child with autism that I don't have. I've got a close family that have children that are nonverbal autistic, and I understand some of the implications, but I don't have the experience you do.
Yes, Your Honor. It's the city of Tumwater versus Mr. Little. At this time, Your Honor, the state is not able to confirm. We have a material witness who is currently unavailable. They are on the other side of the state next week. We are asking for short continuance of trial to the week of the 23rd. So about a 2-week continuance. I did verify with that witness that they would be available on Tuesday or Thursday at 9 a.m., give or take. And they said they were not aware of any unavailabilities at this time.
So September 23rd would be your date to start the trial?
Or the 25th, depending on Mr. Pezderka's preference, as well as scheduling of if there's 9 cases set for trial on that Monday and 1 set for Wednesday, I would probably suggest the Wednesday.
Well, chances are there's a lot of cases set both days, but I understand. All right, Mr. Pezderka, what would you like to do with this?
Your Honor, just for the record, we would object. I understand that the court may find good cause, but Mr. Little would like to resolve this case. He does not want to be waiving his speedy trial rights and is looking to move out of the area and wants to resolve this case before he does so. To that end, I would prefer the Monday, Tuesday, as I believe I may be out of the office that Thursday.
So yeah, looking at the docket, this case is not old. It looks like it was filed in June and it's been expeditiously set for trial. And prosecutor's reason for asking for a continuance is good because if his witness is unavailable and needs the material witness, and he will be available again in just a couple of weeks. I think that's completely reasonable. So let's reset it for trial on September 23rd. And, if it turns out that the witness, I don't think the witness is going to be the problem, but scheduling. All right, so Mr. Little, I'm canceling your trial for the 4th. Instead, we're going to start the trial on the 23rd. That is continuance for cause, and that is an excluded period until September 23rd. No, I think everybody's ready. So, yep, we'll just reconvene for trial on September 23rd.
Yeah, I just realized.
All right, Mr. Little, I think that's it for today. Just keep in touch with Mr. Pezderka. He'll let you know if there's any issues or complications or any changes. All right, thanks for coming in, sir.
We jump back to Judge Wolf, see if we've got a new case.
Only other matter I had Dustin Kendrick, number 1 on the 10:30 calendar. He was present on Zoom briefly. He gave me a call and let me know that he was had to go into a business meeting. We did discuss the case, and I have filed a speedy waiver in the hold for court folder. I adopted this case from Mr. Stillwell, and still be requesting to set this out a little bit farther as I'm still working my way through discovery issues. There does seem to be a lot going on in this case that I need to work on before I'm ready for trial.
State have any objection to that?
No, Your Honor.
All right, we're going to jump back to Judge Wolf. And before we start, the sentencing for Tellus is on Brandy Churchwell's channel. We joined her for both the sentencing and the verdict, or both the verdict and the sentencing. So check out Brandy Churchwell on that one. That's where you can find that. All right, we're going to see what Judge Wolf is getting up to. Sorry, if we can hit all the right buttons here. There we go.
All right. You may.
And after I announce, Your Honor, I would appreciate it if we could at least put my client under oath. I don't know if Ms. Hendrickson wants to do the same.
Let's go ahead and place him under oath now.
She's sick. I thought she was not going
Both
to
of
be
you
here.
raise your right hand and let's place you under oath.
The sick lawyer's back. Judge is not happy about that.
Your Honor, we're going to agree to reset the motion to dissolve the order of protection. We would like to do 10/25 if we can.
October 25th.
Yes, sir. We noticed that you were putting quite a bit of stuff on, but we would.
October 25th.
Okay. Your Honor, we will reset pending matters to October the 25th, 2024 at 9 a.m. We would also respectfully request subpoenas that were issued specifically for the DCS worker and the detective be extended to that date. They are present. Further, Your Honor, the father will agree to obtain a 5-panel hair follicle drug test at a lab of the mother's choosing. Father will pay for the test and submit a bill to the mother for reimbursement, and will have the results submitted directly to the attorneys and to the court.
Wow.
If that 5-panel hair follicle drug test is clean, we will modify the order of protection as follows.
They're going to take 5 hairs?
We will allow communication between the father and the children. That will include any telephonic or video communication.
Is it the bald guy?
We will allow communication between the mother and the father only for the purposes of discussing or coordinating visitation, which will be as follows. The father shall have visitation each Sunday pending the hearing from 10 a.m. to 6 p.m. Pickup and drop off of the children shall occur at the Burns Police Department, and neither party shall discuss or allow to be discussed any aspect of these proceedings with the children.
All right.
Wow.
You want to affirm this with your client?
Yes, sir, Your Honor. Would you please state your name for the court? And Ms. Hall, you heard what I just announced to the court, and we've had an opportunity to discuss that before bringing this before the judge, correct? Do you have any more questions or concerns for me before the judge makes this order? Okay. You do understand that you have an order of protection in place right now, correct?
An eyelash.
And that order of protection comes not only with the protection of law enforcement, but also the protection of this court. And you are agreeing to modify that order of protection in the ways that we have described here. And you are doing that voluntarily and freely.
Ms. Hendrickson?
Mr. Ladd, can you state your full name for the record? Did you hear the details of the agreement? Did you agree to the details of it?
All right. I will approve your agreement and we'll reset it for October 25th for any further hearing, and you'll submit an agreed order. I hope you feel better, Ms. Jackson-Smith.
Thank you, Your Honor, and good luck with your go-go gadget arm.
All right.
Thank you, Judge.
All right.
All right. With Mrs. R.A. a little under the weather right now, I'm going to have to go to the store and pick up all the groceries. Holy cow, lots of people leaving for that
Have
one.
an announcement in the Quigley versus Hale matter.
Quigley?
Step up.
Quigley down under?
The matters before the court, Ms. Quigley has filed an order of protection. Judge, subject to court's approval, we are going to dismiss the order of protection. However, we're going to enter a temporary restraining order. That will be for Chad Hale to exercise parenting time with the minor child on every other weekend, Thursday at 6 p.m., Sunday at 6 p.m., starting Thursday, September the 5th, 2024. The child shall have the ability to terminate the visits should he feel unsafe at his father's home by calling his mother or paternal grandparents. Minor child shall basically have his phone with him at all times. 13, February the 1st. So Mr. Hale is to provide mental health and counseling records via under a protective order for the attorneys to have the records, and those records would not be disseminated or distributed. We're going to reset the matter for
Yeah, I'll come back right after lunch. I just have to go. It's a
parties will
just park in the parking lot and load my car with groceries, and I come back. I'll be back after lunch.
Exchange would take
that I
place
promise.
at Stevie's Market. no limitation on the attending of extracurricular activities by Mr. Hill with a minor child. Subject to the board's approval.
Right, do you want to have your clients affirm it under oath? If both of you will raise your right hand, let's place you under oath.
Yeah, they both agree. Good. Judge is going to agree to this new revised
Could you state your name for the court,
order.
please?
Jessie Quigley.
Okay, and Ms. Quigley, did you hear are you the mother of Kason Hale?
Yes.
Okay.
Who's the kid
and,
again?
Did you hear the agreement that Mr. Vandervoort announced?
Yes.
Okay. And are you in agreement with that?
I am.
Okay.
Ed Hill,
Yes, I am.
you heard the announcement to the court.
Yes.
You're voluntarily entering into this agreement.
Yes, sir.
In order.
Yes.
All right, since both of you have affirmed this under oath on the record today, I'm going to approve it, and it will become an order effective immediately today, even though it'll take a while for the written order. So I want to both understand what you've now agreed to is effective right now,
So
from here forward.
Get away from
Even
her.
though there might not be an agreed written order, it is an order of this court enforceable as any other, okay? Good luck. I hope everything works out. Thank you.
Thank you, Judge.
All right. It sounds like let me jump to this real quick. It sounds like News 3 out of Las Vegas did an interview with Robert Tellis. That's going to be something I won't be able to share. They would hit me with a copyright strike pretty quick, I think, on that one. It's an exclusive they produced out of court. That would be tough, but it might be something worth watching, especially if Mr. Tellis is doubling down on now the jury, clearly Compass Realty got to the jury. I wonder if he's going to double down like that, or if there's any sort of remorse. I doubt there will be any remorse. Let's see. Sorry you're under the weather. Sending flowers. Hope you're not allergic. No flowers. Not needed. She's just, it's her voice thing, and her throat's hurting, so she's been trying to rest it off. And we bought all the cough drops that CVS had to offer. News 3, let me see if I can get you a link so you can watch this during lunch. We might talk about it after. News 3 was one of the channels that was actually local. Well, they're local to News 3 Las Vegas. They're out of Las Vegas, but they're one of the channels that were there present for the trial. Tejas interview. I'll put a link in here for you. Two days ago. Okay. Oh, you know what? It's not new. I don't think it's new. Let's see. Hold tight just 1 second. Let me take a quick look at it. Let me just confirm. Okay, it is new. Okay, I got it. Let me post this in chat for you. This is something you guys can watch during the lunch break. It would be great. And I'll put the YouTube link up here right now. Just 1 second. I'll paste that there. Let me play my outro and then I'll post it. Is that okay? There we go. All right, I'm going to go to lunch. We'll let you watch this interview, which I think is, let's see how long it is. Looks like their story is about 18 minutes long, so it's a good watch for the lunch break. I'm going to go get the groceries at the store. I think I just park and they load my car. So, I mean, how can you complain about that? It's a risky click. Here we go. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, because it is Friday after all. Please stay safe till we go live again after lunch when I have groceries and food in the house so the kids are happy. And we'll be back with some more court watching, some more discussion about some of the happenings in other trials. If you see something happening, as always, reach out to me on the burner phone. We may be able to cover it live as it goes on. Okay, there's the link. Well, I tried to put the link in chat. Come on. There we go. There's the link to Channel 3's news story about Robert Tejas. Give me about an hour. Does that work? Hour lunch? We'll be back this afternoon. It is Friday. It's Friday. We waited all week for this. Super excited. I think we even have a holiday on Monday. How can that be? It's amazing. You guys be safe till we come back. We'll see you afterwards. Bye-bye.